the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you, Gio. Good morning. Welcome to the Massachusetts Appeals Court. I'm Judge Desmond. My pronouns are he, him. To my right is Judge Ditkoff. To my left is Judge Englander. We'll be your panel for all 5 cases that are on our docket this morning. You should know that we've read your materials and we're familiar with the cases, so you don't need to necessarily give us a long bit about the facts. We're familiar with those facts, but of course each side gets 15 minutes and it's yours to use as you see fit. There's no rebuttal. Our first case on the list is 24P0540, Alexander Santiago Rosa versus Affordable Interior Systems. Mr. Lee for Mr. Rosa.
May it please the court, George Leahy for Alexander Santiago Rosa. This is the second time this case has been before the appeals court. Judge Ditkoff was on the panel back in March of 2022. That case was overturned and remanded back down to the Superior Court. Obviously, we're back up here today for some of the same issues that were addressed at the first appeal. The court very narrowly, and as they should have, addressed the first appeal on a procedural issue and not necessarily the substantive grounds. I know Judge Englander has an undergraduate degree in mechanical engineering, so he's probably going to be a bit more cognizant about unguarded chain and sprocket assemblies on different pieces of manufacturing.
Give me far more credit than I deserve.
I didn't go to Cornell and get a mechanical engineering degree, Judge, so I'll defer to you on that.
The first matter, you prevailed because the trial court had looked beyond the motion to dismiss at some other outside documents, and they sent it back.
Correct.
Because they effectively had considered it as a summary judgment motion, correct?
Right. And this
so
was...
I see your papers now. In your reply brief, you say that the motion to dismiss is somehow still before us. Is that what you say?
No, Judge. What had happened is as soon as, in fact, this had come up in the first argument, my oral argument, and I wanted the court to basically rule on the substantive issues at the first time, was to say, in essence, and what ultimately defense counsel did is, as soon as we got back down to the Superior Court, he refiled for summary judgment. The Superior Court judge then at that point in time said, no, we're going to let you do some discovery in the case. We probably took over 6 depositions, 7 depositions maybe, to flesh out the factual issues in connection with the case. They then allowed me to supplement the the summary judgment motion, which was unopposed, based upon the deposition testimony that we'd secured down below. The judge in the Superior Court then allowed the summary judgment motion, but when she did so, in essence, if you look at the broader picture that's before this court, the Superior Court judge is going to say, if you're a temporary employee coming in, you don't have to sign a waiver because a waiver doesn't matter.
We get to that. So just so that I'm clear, the only thing that's before us is the allowance of the summary judgment motion.
Yes.
Maybe I was confused by your reply brief.
I did not file a reply brief in connection with this case, Judge.
Well, there it is.
All right. There was a motion for reconsideration put before the Superior Court judge. In essence, what I try and do in that thing is to say, listen, before we take all the time and effort to come to the appeals court, which is candidly very expensive.
Let me just, I'm sorry to interrupt, but what's your argument? Is your argument that as a matter of law, in order to prevail, the defendant had to show both that they fell under as a special employer with the appropriate insurance, and that your client signed a waiver?
Yes.
Where do you get that from?
Molina. And Molina was
Molina says exactly the opposite as I read it, though, counsel.
Well, the issue that you've got is if you look at Molina, it was a combination of 2 other cases. One was Horner versus Boston Edison, and the other was the Lang versus Edward J. Lamoth case. Horner versus Boston Edison was an individual who was hired to go through the Pilgrim nuclear power plant, and he had signed a waiver. He slipped and fell and was injured, and he attempted to sue, in essence, Boston Edison. The court in that particular case indicated that the waiver was valid, that the consideration was effective because that was a condition of his employment, and therefore that satisfied the consideration associated with that. Then we dropped down to the Lang versus Edward J. Lamoth case, where they, in this case, the special employer, much the same way as Affordable Interior Systems, Inc. did, tried to get out and say, oh no, we're covered under the workers' compensation policy, therefore we get the immunity that's afforded to us under that. The court in Lang said, no, you didn't put your name on the policy, you're not listed as a named insured.
Right, and the judge here distinguishes Lang. Molina distinguished Lang. The judge here distinguishes Lang on the ground that the policy did cover the special employer.
The problem
right? One of the arguments I see that you make is that you don't think that that policy's been read properly, but you also make this argument that in order to be immune, in order to come under the comp bar, you have to both have a waiver and fall under the Section 24 comp bar, right?
Correct.
But Molina says it addresses the waiver separately, which probably was a mistake on the part of the court since they'd already ruled that the defendant was immune from suit, and then they go on to Section 2, validity of waiver and release, and then they finish that with, in addition to having immunity under the Act, State Garden is protected by the waiver. In other words, it's a second separate reason why they won. You didn't need them both.
I disagree with that from a practical aspect. You're going to turn the whole system upside down if you take that away.
Okay, explain that.
All right, the reason is this is, let's say you have a Section 28 under Chapter 152 case, which is double comp, all right, for an employer who goes in and does something that's willfully wrong that injures an employee, akin to almost gross negligence. How is somebody like Alexander Santiago Rosa, who doesn't read or write English, all right, doesn't speak English, possibly going to understand that he's giving up his right to the lawyer that represents him in the workers' compensation case? How is that lawyer going to know, absent some kind of a waiver, all right, that this situation was done between, you know, the special employer and the general employer?
But why does he have to know? I mean, I understand, I think I understand the concern that you have. But what the law is saying is that in this context, we're going to sanction the notion that there are two different entities that are going to get the protection. The general employer, the staffing agency that hired him, and his special employer, as long as that's the person who had control, that's AIS. And the law is saying we're going to sanction it, we're going to protect them both. What's wrong with that? Because it seems to me you're arguing as a policy matter, almost, that that's what the problem is.
The problem that you've come is, you in essence have somebody like Alexander Santiago Rosa who's giving up his tort rights, all right? Specifically under Chapter 152, Section 15, they reserve the right to pursue a third party who's responsible. Mm-hmm. There are also, and I put it in the footnotes, and it becomes complicated. What happens is there's experience mods that come down, which is in a retrospective policy. The public policy behind it is, if you're a dangerous employer, you're a dynamite factory, and your employees get hurt, then what happens is that workers' compensation carriers, based on the number of accidents, increase your premiums, called the experience mods, or modifications. Now, in a retrospective policy, and they can opt that for 3 to 5 years or open-ended, if a company like the manufacturer of Affordable Interior Systems, or a product manufacturer, for example, a particular machine manufacturer, is held responsible, I have to pay back on behalf of the employee under Section 15 all of the workers' compensation monies. That in turn goes back and they adjust the modifications to the workers' compensation policy to the employer and reduce his premiums. He gets a refund of what the increased cost would be for that particular accident.
But I'm not sure why we care about that. I mean, I thought that the issue was, the statute says that if you are the employer, you are protected as long as you're insured under comp and the comp is paid. That happened here. There was comp insurance and it was paid, right? The employer therefore gets the bar of 24, right?
That is correct.
Okay, so now the only thing we're worried about, the only thing the judge below was worried about, is who is the employer, quote unquote, who gets that protection, right?
That is correct.
Okay.
And that's what the judge said down below. I disagree with the
Statute
judge.
says that there are circumstances, the statute and the case law says there are circumstances under which that can be more than one employer. It can be both a general employer and a special employer.
That is correct. If it's done,
Okay.
if it's done correctly, yes.
Okay. So what was done incorrectly here?
Two things. One is the waiver, which I'm going to stick to. I know you don't like that, Judge, but mine is as a practitioner who's done this. I've done many of these cases before down below, all right? Somebody is giving up their tort rights. They have a right to know that when they're coming in.
Well, I don't understand that. I've had lots of jobs covered by workers' comp, and no one ever told me I had a right to, I was giving up rights or that I had a right to waiver.
He still collects workers' comp from the general employer, which would be Randstad North America, Inc.
Right, so whenever you take a job, unless you file this special waiver,
Correct.
you're covered by workers' comp and you don't get to sue. No one ever tells you that. No one ever says, hey, you can file a waiver. So why is that a problem?
The problem isn't that because he collected the workers' comp. The problem is he's losing his tort right. Workers' comp only pays 60% of your gross average weekly wage to a cap. Workers' comp is capped at 250 weeks. After that, you're bounced, unless you get temporary total in connection with
I just
it.
don't understand why you would need a waiver if it's an alternate employer, but you don't need a waiver for the general employer, which is what most people have.
That was, I think Massachusetts was, correct me if I'm wrong, the first state that adopted, I think, workers' compensation. And that was a public policy consideration because other than that, somebody would get injured. If they didn't have workers' compensation, they can't pursue, they couldn't sue the employer. They wouldn't have any money. They're disabled. Even today, Mr. Rosa is unemployed as a result of the serious injuries that he had in connection with this case.
So you read Molina to support this argument?
I read Molina, and you're parsing out the words. There's one sentence in Molina that defense counsels, hang his hat on, and I'm sitting there going, you're going to hold those from the semantics and the phrasing of the words in that to give up your tort right, all right, in connection with that. And also, too, as I had alluded to before, normally, if I did not handle the workers' compensation case down below, that was handled by another attorney. That attorney, if they had known all of these factors, let's say that he did not prevail in this case before this panel, let's say I don't win this case, they could have pressed a Section 28 case because there's no question Affordable Interior Systems, they didn't have a supervisor that understood the machine, they didn't turn it off, they got fined by OSHA, they paid the fine, they reduced it down somewhat, they took off the guard and the chain and sprocket assembly, and they also admit that they failed to provide them with a safe place to work.
So Section 28 case, is there some way to jump out of the protections of the Worker Comp Act and have a lawsuit against an employer? Is that
It just
what
gets
you're
you
suggesting?
double recovery, right?
Yeah, you're correct, Judge. What happens
But
is
you still can't do a tort.
you can't do the tort, but it compensates the employee, all right, more so than, let's say, on workers' comp. If I'm workers' comp, I don't get pain and suffering. I'm capped at 250 weeks. I get 60% of my average weekly wage, and I'm capped out. Section 36 is for scarring and disfigurement. There's a formula that's done on that. It's very minimal for somebody like Mr. Rosa, who's basically got a claw for a hand and has had 4 surgeries.
I'm no expert on workers' comp, but I think what you're just saying is that argument could have been made. That argument could have been made here because of the nature of the way that the harm came about for your client, right?
But how would anybody know that as the lawyer to represent Mr. Rosa at the time?
Because you knew the nature of the act? It sounds to me, I don't know, it sounds to me like what you're saying is if you engage in sort of outrageous behavior as an employer such that there's an extreme risk of harm from what you do, then you can fall under Section 28. Am I getting that wrong?
Well, Section 28 is basically what it comes down to is of Chapter 152, whether there was serious and willful misconduct of the employer.
Well, why can that argument have been made based on what you knew about how he got harmed?
Because OSHA did not fine the Randstad North America, Inc. OSHA fined Affordable Interior Systems. So when the lawyer looks at that and refers the case out to me for the tort, all right, they're saying, okay, great. How do I pursue that before the industrial accident board?
Are you saying the other attorney didn't think that this temping agreement probably had an alternate employer endorsement for the clients of the temping agency?
As a practical matter, how are you going to know that? We're arguing it today because we have that policy. That policy is not an ISO policy, which is Insurance Standards Office, which is, this is a custom policy. The ISO policies are done for insurance companies to give you standard form policies. And then what they do is around the country, people can look at the different insurers as to how the courts interpret that policy so that they have a firm basis to know whether there's coverage or there isn't coverage. This appears to be a custom policy. It is not, and if it's an ISO policy, it
Almost identical language to Molina, isn't it?
they copy it. Why? I mean,
Okay.
no one's foolish about this, meaning if you're down below.
Molina was decided, well, okay.
2015. So at the end of the day, Molina's your best case?
Yes, Judge, and basically, if you look at either one of them,
I see that's your time. Thank you kindly.
yeah, my time is running out.
No, you're over your time.
I'm sorry? I'm sorry, oh, red light. Thank you, Justice, I appreciate the time.
We'll now hear from Attorney Ryder.
Good morning, Your Honors. May it please the Court, Ethan Ryder on behalf of the Appellee Affordable Interior Systems, Inc. Your Honors, I'll just start off right where my brother left. One thing we certainly agree on in this case is that it relies upon Molina. Contrary to the assertion, I don't just rest on one sentence, I rest on the entire ruling of Molina because this case is directly aligned with it. Just as an initial note, neither Molina, Lang, or any other case that I'm aware of has made a valid waiver a requirement of the so-called two-part Lang test. I'll get into the specifics of what's required, but as the Justices noted, it is not a requirement in Molina. Specifically, in Molina, this Court opened by noting, with respect to the judge in the Superior Court, as is the case here, the judge allowed the motion for summary judgment on the ground that the alternate employer endorsement shielded, State Garden in that case, the special employer, from common law liability under the exclusivity provisions of the Act. We agree. We also conclude that Molina's action is barred by the waiver and release he signed. So as Justice Englander noted,
Hold on.
Yes,
Count 2 and 3 couldn't be barred by the waiver, right?
that's correct, Your Honor. So neither at the motion to dismiss nor at the motion for summary judgment have we taken the position that it would apply to gross negligence or recklessness and willful conduct, just with respect to common
Just to
law
make sure I got it
negligence.
right, both the workers' comp and the waiver, in your view, block count 1, but the workers' comp is the only thing that blocks count 2 and 3.
That's correct, Your Honor.
Okay.
Workers' comp bars all claims, but the release would just reply to the common law negligence claim. And as Justice Englander noted, the Court concluded that in addition to having immunity under the Act, State Garden, in that case, special employer, was also protected by the waiver and release. So moving on from the fact that a waiver and release is not a requirement of immunity, the actual two-part test is that, in this case, the special employer, my client, is an insured person under the Act, and that they are the direct employer of the individual. In this case, as was the case in Molina.
Let's take the first of those. Are you on all fours with Molina? the amendatory endorsement has this language for claims arising out of the, no client is an alternate employer for claims arising out of the alternate employer's negligence unless the applicable contract specifically denotes such an obligation. Was that language in Molina?
I don't believe that language was,
Okay.
Your Honor.
What does it mean to specifically denote an obligation to cover the negligence? What does that mean?
Absolutely, Justice Engelder. So I totally agree with the motion judge with respect to her analysis of this, in that the staffing agreement between Randstad and my client specifically provided that Randstad would be solely responsible for handling all unemployment and workers' compensation claims.
Specifically denoting that they're going to cover negligence as well?
Your Honor, our position is that all claims are all claims, and to run with that.
What does it mean to specifically denote, counsel?
So,
I mean, I would think that that would mean, and we cover negligence claims.
so
That's not in there, right? It just the word all. Your entire argument hangs on the word all.
exactly, Your Honor, both the totality and the convenience of all claims. But to run with that thread, if the language had said covers all claims including negligence, then no one could argue that, okay, negligence is specifically denoted, but nothing's added. It's just noting that, oh, negligence is part of all claims. If to take it one step further, if it read to cover all claims and negligence, then it's, hang on, is negligence not part of all claims? It would seem as though to have my brother's position, instead of having the totality and convenience of all claims in a document, you would have to then list out every single potential claim one by one by one by one by one, but then you would be in a position where...
Well, it just says you have to specifically denote negligence. But I wonder whether, I mean, the carrier covered, right?
Exactly.
This is in the carrier's policy, right? This language, this specifically denoted language, is in the carrier's policy.
That's correct, Your Honor. Yes.
Yeah. And so the carrier covered.
Yep.
And the workers' comp was provided.
Exactly, Your Honor. And as specifically noted on the endorsement, both Part 1 with respect to workers' comp and Part 2, the employer's liability, will apply as though the alternate employer is insured. So just as the case was, workers' compensation was paid out on behalf of the named insured, Randstad. It's also, we are the employer, based upon the language of the alternate employer endorsement, my client AIS, by being named such an alternate employer and an additional insured under the policy.
So what'd they pay out, like 40,000, is that right?
I believe the settlement was 189, Your Honor.
And 89,000 on a total bill of what, 440?
I have the...
Are they still paying on his medical bills, by the way?
I'm not sure, Your Honor. So the lump sum settlement was approved back in December of 2021. As of that date, the total payments were $189,365. There is also the indemnity. The lien is, I believe, $220,000, of which I believe $19,000 is medical and the rest is indemnity. So the fact that, as in Molina, that my client was added as an additional insured, I'll just note that there was raised issue with respect to a so-called blanket endorsement, in that my client isn't specifically named in the amendatory endorsement, and somehow that should take away from my client's ability to be named.
Cases that talk about the word specifically denotes, is that a standard language in these policies?
I'm not sure, Your Honor, with respect to specifically with respect to specifically denotes, excuse me. But just with respect to all clients, there is no question that my client was, in fact, a client of Randstad. That's clear in the staffing agreement. So I'm happy to move on to, I don't think there's any dispute in this matter that my client was the direct employer under the two-part Lang analysis.
They just have to have a certain amount of control, right?
Correct, Your Honor. And the allegations, both in plaintiff's complaint and the OSHA investigations that were referenced, were that my client controlled the operation, the supervision, the oversight, the training, et cetera, of the assigned employees, in this case including Mr. Rosa himself. With that, Your Honors, the Superior Court didn't reach the question of release. I'm happy to discuss it. I'm also happy to turn over to any questions or rest on my papers, whatever is for the convenience of the court.
Matter stands submitted. Thank you both.
Thank you, Your Honors.
Next matter on our list is 24P0465, Andover School Committee versus the Commonwealth Employment Relations Board and another.
Damn it.
See if the appellees are splitting their time, is that correct?
Yes.
Excuse me,
Attorney McGovern?
the appellees are splitting their time?
My understanding.
Yes, we are splitting our time.
Okay, just because I have 7 minutes on the clock, but I'm not splitting my time.
Oh, no, you shouldn't have said it.
15 minutes.
Oh, okay. Thank you. Your Honors, and may it please the Court, Ryan Quinn for the Andover Education Association. I know you have the briefs in the record, so I'm not going to go into everything, but I'd like to use my time to focus on two issues. First, I would like to clarify the nature of the constitutional claim that the union makes here. And second, I would like to attempt to provide the court a narrow statutory ground on which it can resolve this without reaching those constitutional issues. This is a case of first impression with respect to the constitutional issue. It's undisputed that the board's interpretation of Chapter 150E goes back to 1982. It's undisputed that in 1990, the Supreme Judicial Court approvingly referenced that in a case called Anderson versus Board of Selectmen of Rentham. But it's also undisputed that no court has addressed the constitutional issue. And the constitutional issue here is this. In the absence of any statutory right to collective bargaining in Chapter 150E, the union would undoubtedly have the right, the constitutional right, to petition town meeting asking for an increase in pay. The central constitutional question here is whether the passage of Chapter 150E eliminates this right to petition, whether it limits that right to petition in some way. And the union simply argues that for the statutory collective bargaining right to restrict the union's constitutional right to petition, that restriction has to meet strict scrutiny, and strict scrutiny is not met here.
Why isn't strict scrutiny met?
The case for strict scrutiny is that the board's interpretation of Chapter 150E discriminates on the basis of speaker. The board concedes.
Okay, it does. Okay, so why doesn't it pass strict scrutiny?
Why doesn't it pass strict scrutiny?
Yeah.
Well, to the extent there is an interest identified, the interest is the system of
Having public employers enter into a labor relations structure that makes sense, because otherwise they'll be negotiating, and then the union will be allowed to go outside the negotiations and ask town meeting to supervene them. Sounds like a pretty important interest, isn't it?
That is an important interest.
This is what happened here, right?
It's not what happened here. That, I think, is another case. Now, did the union attempt for that to happen here? Probably. Probably the intent was to achieve a bargaining goal.
Article 1 passed, or was it Article 1 or Article 5 at the time?
Article 1, yes. Previously Article 5, but Article 1 did pass. It was not enacted. It was not implemented. This is in the undisputed statement of facts, and the SERB found this as well. It was not implemented, and it was not implemented because town meeting can't direct a school committee to pay people any particular benefit. And that's not really a labor law issue. That's a division of authority and power within the government. Now, the union's...
Why isn't it exacting scrutiny instead of strict scrutiny?
Exacting scrutiny.
That's what Janus uses, and it's been used in commercial since.
Exacting scrutiny, exacting scrutiny, I think the reason it's not exacting scrutiny is that this is based on the speaker. It's true, Janus, in the context of...
But if it's a commercial speak, I mean, if we're talking about speech, we'd think about this as commercial speech. People want money, wouldn't we?
So you're suggesting that it would be a lesser standard when a union
I think that might be what Judge Ditkoff is suggesting too, although he knows more than me as usual.
Well,
I mean, they're literally coming to someone they want to do business with and saying, I'd like a certain price. Seems like core exacting scrutiny.
Well, I suppose the difference is that we're talking about coming to town meeting. I mean, my case for this would be Barron versus Kalenda at the SJC in 2023, but this is not commercial speech.
Is there a case that says if you are negotiating a commercial relationship with the government, it's not exacting scrutiny, it's entitled to a different standard?
I'm not aware of a case that says that, no. I think the key here is that this is not a union coming and saying, we want this other deal just for us. This is an issue of public importance put before the members of the town meeting.
They're asking for money.
Sure.
So it's an issue of public importance only because the union thinks it is. It's commercial, right? I don't know, and I think Judge Ditkoff has read more cases than me.
That's unlikely.
Whether the petition clause has different set of rules with respect to the way it thinks about things than free speech clause. But if it were a free speech case, I at least would think of this as commercial speech. It's not an ad, I agree, but it's also not core political speech. It's something less. No?
I think Janus and probably the City of Madison versus Wisconsin Employment Relations Commission, Supreme Court 1976 case that's discussed in I think all of the briefs. I think those cases make it clear that this is core political speech, notwithstanding the fact that we're talking about terms and conditions of employment for employees. This is core political speech. The City of Madison case here is instructive. In that case, we have sort of the inverse of the situation here. We have an individual teacher attempting to speak directly to a school committee rather than a union. And that individual teacher is speaking about a subject of bargaining, and the the state agency said the employer violated its duty to bargain in good faith by having that conversation. And the court said, all of these terms and conditions of bargaining are necessarily key political issues. There's no subject of bargaining that isn't going to be a political issue.
Any public union or public employee, whenever they speak, it's political speech.
Not any public employee.
About their own about their terms and conditions of employment, it's political speech.
For an individual employee, I would say there are restrictions on the Pickering line of cases and Garcetti versus Ceballos and O'Connor. Those aren't in the briefs because I think that's about disciplining an individual employee, and there are greater rights that the government has to restrict that speech in the capacity as an employer. So an individual employee, I think there's greater restrictions that are permissible. But here, the question is, does a union have fewer rights than some other person speaking to the town of Andover? And I think if there's going to be that distinction on the basis of who is speaking, then there needs to be some significant, compelling government interest.
Doesn't it arise from the fact that the union has affirmatively gone to the government under the labor relations laws and said, I want to be identified as the exclusive bargaining agent for these people? Right? That happened, right?
Yes.
So your client did that. And when they did that, didn't they bring themselves under the state's labor laws? And the labor laws said, okay, you want to be the exclusive bargaining agent, here are the rules. Now, why can't the state do that?
It may be that they can. It may be that they can. I have to concede there's some version of a labor law where this would be central to the system of collective bargaining. That's not in the legislative history, and there is a legislative history for Chapter 150E. There's some indication of what the legislature was intending to do, and this doesn't come up until about a decade after the law was passed. So it was a late entrant into this.
I'm not sure
labor
what
law.
you mean by this. I mean, again, the way, and I'm by no means speaking for the panel, the way I would think about it is, okay, I say I'm the exclusive bargaining agent, and I'm certified. Now I'm under 150E, which includes an obligation to negotiate in good faith, right?
Yes.
Okay, and that means negotiate with the exclusive bargaining agent for the other side in good faith.
Yes.
Which is the school committee, under the rules.
Yes.
But that's not what your client did here. Your client instead said, well, I couldn't get it from the school committee, now I'll go see if town meeting will give it to me.
So, to clarify, when I say this, I mean the particular interpretation that going to town meeting is bad faith bargaining. That this is not necessarily inherent in a system of collective bargaining and exclusive representation. It's certainly a permissible interpretation of the statute, but it's not the only interpretation. And I think I think Anderson tells us Anderson effectively says this is a reasonable interpretation. I think the SJC said that, but I don't know that it is responsive to the constitutional issue. Now,
So before we run out of time,
yes.
SERB also found that the union was not bargaining in good faith when it agreed to the MOA and executed the amendment to the collective bargaining agreement. What's wrong with that?
I'm sorry.
The SERB finds on page 16 that the union was not bargaining in good faith when it agreed to the MOA in March. So what's wrong with that?
What's wrong with that? I think that is, I think that is probably a permissible interpretation of the Commissioner of Administration and Finance case, which is referenced, I believe, in all the briefs. More recent, probably 2017 SJC case that looks at post-bargaining conduct indicating bad faith during bargaining. So I would say that is, we don't challenge that. We have not challenged
So
that.
why isn't the case over now? There's a finding of bargaining in bad faith that you say you're not challenging, and so why don't we just affirm on that? Why do we have to affirm on every ground?
I think you could affirm on that ground and avoid the constitutional issue, and I think that that would leave open. I think that would leave open the right to petition in the future, and it is, maybe a future case. But I will grant that is open to the.
I'm guessing the future case will have better facts for the union than this one.
Possibly. If I see that my time's running out, if I could just briefly lay out a line that I think might.
If it's okay, I have some technical questions, and then can we give him an extra minute? Sure. So we'll give you your minute to sum up. You raised in the end of your brief that direct bargaining with the town ought to be allowed, but I didn't see any place that was raised in front of SERB. Am I missing it?
Direct bargaining with the town?
Yeah, sort of near the end of your brief, direct dealing on page 36. You suggest that should be allowed, and I didn't see that in the SERB, raised before SERB.
I see. I think this is that was intended to be an argument that direct dealing, not that it should be allowed, but that the theory of direct dealing as applied to a union is a poor fit in the law. I don't want to overstate that argument by saying the argument is that it should be allowed. It's that there's a harm when an employer does direct dealing, that you undermine the role of the union in the eyes of union members. That doesn't exist. That's not, you don't have the same harm with an employer.
And the other, thank you, that's really helpful. The other technical question I had is in your brief you say only the town could disperse the ARPA funds, and I didn't see any basis for, it's not in the facts. I mean, I could see why that might factually be true, but it's not in the facts, and I didn't see anything in the law that required that.
So my brother counsel, Attorney Foskett, from the school committee, I think probably has the better argument on this. As I was going through the briefs to prepare for argument, I have to say, I think he makes a compelling case that as a legal matter was not the case. I think it may have been that a more thorough factual record would have shown that people thought it was the case, but that's not in the facts. And I think it's probably true as a legal matter. It was not, that wasn't the case.
All right, thanks, that's really helpful. You can have your minute.
Thank you. Very briefly, there's a line drawing issue here, I think, because there are some examples one could come up with of petitioning the government that would be, clearly permissible. We want an increase in the minimum wage when people are in the bargaining unit are currently making the minimum wage, and you go to the State House. This would directly change wages, hours, working conditions, but I don't think anyone would be bringing a case like this. The line we ought to draw, and the line that I would ask you to draw, is precisely the line that the SJC drew in Anderson versus Board of Selectmen of Rentham in 1990, and that is when the benefit has been, quote, inflexibly established by town meeting at the union's urging. And that didn't happen here because the town meeting, as a legal matter, cannot direct that the school committee set wages at any particular level. And we know that factually because it didn't happen here. It didn't happen here. There's cases at, I believe, page 30 of the union's principle.
Why go through the process then?
Oh, I suspect that...
From your client's perspective, if your position is, look, this was an empty formality, didn't matter, school committee could just say no. Why go through the process?
Well, I think it's a democratic process of putting the pressure of town meeting on.
Negotiating.
Right.
Okay.
Let me ask you this question, if I may. Do you think, had you not brought it to the school committee, I mean, here you bargained for it and you couldn't come to any resolution. Had you not done that, do you think you could have brought it to the town council in the first instance?
Could we have brought it to the town?
Meeting?
I think that would have been unlawful under the logic of the SERB's decision. I think it's the fact that it is a mandatory subject of bargaining, not that it was bargained recently, is the basis of the decision.
So
but
your position is that even though it was a mandatory subject of bargaining, we did that, we satisfied that, got nowhere, so then we were able to take it to the town meeting.
yeah, I don't think the union's position is that because it wasn't achieved, they could then go to the town meeting. I think it was that they could go to the town meeting regardless of what was happening at bargaining, because town meeting does something different than what the school committee does. School committee negotiates terms and conditions, town meeting appropriates funds. This was an appropriation of funds. That I think is the union's position. But the SERB's decision does, I don't think, rest on the fact that the union had just recently negotiated for something similar and failed to get it. Would a charge have been brought if the union had not recently done it? Maybe not, and maybe we wouldn't be here, but the logic of the SERB's brief doesn't rest on that. Unless you have further questions, I would rest on my brief.
Hearing none, thank you, Congressman.
Thank you, Your Honors.
How do you pronounce your name, Attorney Goodburlett?
Goodburlett, yes. May it please the court, Kathleen Goodburlett for the Commonwealth Employment Relations Board. The Commonwealth Employment Relations Board respectfully requests that the court affirm the Andover decision, holding that the union bargained in bad faith by bypassing the school committee and in violation of Chapter 150E, Section 10B2, and that the union's bad faith bargaining is not constitutionally protected. The SERB's decision is based on well-established case law, and there are no factual issues. I'll discuss constitutional issues and then the mechanics of bargaining and funding from 150E. At issue in this case is not only the union's speech supporting the town meeting Article 1, but its conduct in bypassing the school committee. This court found in the 2009 BTU case.
So the statute says.
Conduct, not speech?
I'm sorry.
I'm sorry, go ahead.
The statute says what the union can't do is refuse to bargain collectively in good faith with the public employer. And we've already talked about how the signing of the MOA didn't comply with that. But if we put that aside, how does going to town meeting violate that duty?
I'm really glad you asked that question.
Excellent.
Because if you look at 150E, you start with Section 6. Section 6 says the parties, the union and the employer's representatives get together and they are required to bargain in good faith. Then you go to Section 1. Section 1 designates the legislative body as the party with the appropriation parties. We're talking about the general court, the city councils, town meetings. And then you go to 7B. 7B requires the parties, when they conclude an agreement, they require the town's representative to go within 30 days to the legislative body. And then in the context of schools, when you look at Chapter 71, Section 34, that requires a legislative body to establish a total appropriation, and then the school committee makes, expenditures within that appropriation. So you have this very structured approach in terms of defining the role of the legislative body as the entity that makes appropriations. And then you have the role of the representatives on behalf of the exclusive representative for the employees, the union, and the employer's representative, which in this case is the school committee. Their role is to bargain the agreement. And as the Anderson court recognized, if you have this situation where the union is allowed to make an end run around the school committee and go directly to the legislative body, something that is not provided for in the statute, then you have a situation where the entire
But the SGC said that the problem there is when you got to the bargaining, it would inherently be bad faith bargaining because under the theory, the school committee wouldn't be able to say no. And so the bargaining would be bad faith. But I don't know why, when you do have to go to the school and they can say no, which they did here, why going to town meeting violates this duty.
Why going to the legislative body violates the duty
The duty to refuse to
faith?
bargain collectively in good faith.
Run that by me, Ben.
Well, let's take this example. If they had agreed and the school committee was going to town meeting to get the appropriation, there's nothing keeping the union from also coming up and saying, yes, appropriate, this is a fantastic idea, right?
In support of the general collective bargaining agreement, exactly. No problem with that. We're not going to interfere in anybody's right to do that.
So why can't a union go to town meeting and say, there really should be a higher appropriation for school committee, and, we're going to ask the school committee to give us some of that money, but either way, should be a higher appropriation so you can have, all kinds of better school stuff, including better salaries and more employees.
Right. And
why would that be a violation?
partially because of the structure of 150E and the bargaining requirements under that I just explained. But also, you have to remember that the bargaining relationship is between the employee's representative, the union on one side, and the employer's representative on the other side, which in this case is the school committee. That is the relationship between those two entities. So in this case, the union was not without recourse. If this grant came in, and let's be blunt, grants are rolling in all the time. So this is not an uncommon sort of situation. The money comes in, let's say the union saw it and said, hey, listen, our people should be entitled to this. They've been working hard. Their obligation was to go to the school committee, request that the school committee reopen the bargain that they had just concluded 3 weeks beforehand, and say, we would very much like to bargain on this. Now, the school committee had the right to say, no, thank you, you forgot to put in a wage reopener
Can I stop
provision.
you there for a second? I just want to make sure I understand. Your position would be that if they generally went to town meeting and said, you know what, you're allocating $15 million for the school committee, it's not enough. When you're thinking about the budget, you need $17 million for the school committee. That would be unfair. That would be an unfair practice.
I think, generally speaking, the union has the right to bring general political pressure to bear on the town meeting and the school committee. The difference with this case is that it is a very specific proposal that goes straight to how the
But we are in a
school
line
should
drawing
appropriate
exercise.
money.
So is that the difference? Because they're saying how the money should be directed?
Because they're going after a specific proposal. They're introducing a warrant in the town meeting with a bargaining proposal that, by the way, 3 weeks before was on the table between the two parties. I mean, the real issue here is, what is the procedure to bargain? Who are you bargaining with? If a normal person is going to reach an agreement on something with somebody, they expect, okay, this is the final agreement. You don't have a third party come in and say, oh, well, I talked to them, outside and we agreed on this.
They did bargain with the school committee initially, right?
They did. But the bad faith piece is going outside around the school committee.
Hadn't those negotiations concluded?
The negotiations had concluded, and
How's that going outside around them if they'd already concluded the negotiations?
because when a party concludes an agreement, a collective bargaining agreement, I mean, this goes to the essence of 150E, stability and predictability. You know that contract is in place for the next 3 years. It cannot be unilaterally altered. And if I could, I see I'm down to 1 minute.
Yeah, well, it's up to Judge Desmond as to whether we have a little more time, but I don't know. I'm struggling now with something that I thought I understood. So suppose, hypothetically, instead of going and getting a warrant that said, pay everybody $800 who's this type of employee, they said, the school committee just signed a collective bargaining agreement that allocated $15 million to wages and hours. Pass a resolution that it should be $17 million. Would that be a violation of the labor laws?
Absolutely, because they're going straight to the town meeting seeking a legislative
Our
act
teachers
to
aren't getting
appropriate.
paid, our teachers aren't getting paid enough. So now we have what is clearly a political speech, core political speech by the union, right? And you want to tell us that's not constitutionally protected, which were the words you used when you started. Or do you have to pass some standard in order for that to be lawful on the part of?
The Supreme Court addressed this in the Smith case, right? You have to distinguish negotiations under 150E from
Which Supreme Court?
the 441 U.S. 463, where the court states, First Amendment rights are no substitute for labor laws. There's a fundamental difference between the union's right to engage in collective bargaining as the exclusive representative and its rights of free speech and petition outside of that process. What we're concerned about here today is the
I would be
bargaining
stunned, I
process.
haven't read the case. I would be stunned by the notion that the First Amendment doesn't apply, rather than the government having to show that it has some sort of interest, either an exacting interest, a compelling interest, a substantial interest.
And the government does. The Commonwealth has a compelling interest in labor peace. This is what Janus talked about, and this is what the Anderson Court, Branch, the 2019 Branch Court.
Let me try judging Linner's hypothetical a little differently. I was on town meeting for quite some time in Brookline. So we start labor, a contract negotiation, and of course the school committee says, what the union's asking for, we can't fund. We'd never get that much money from town meeting. It's insane. It's 10 million more than our current budget. And so what if at the next town meeting, the union came in and said, you hear what the chairman says, budget's $10 million too low, here's our warrant article to increase the budget and, take that from roads and the senior center and all that stuff and add 10 million because apparently that's what's keeping us from a contract. Is that an unfair labor practice?
In your example, I don't believe that was the union president or union executive board member.
Well, let's say it's
and-
straight union, it's union president, they got a little union bug on the papers they're handing out to the town meeting representative, I know this is open town meeting, but representative town meeting members, the union's doing it, but in furtherance of this, is that an unfair labor practice?
Again, the union can bring its political pressure to bear on the school committee, which is its bargaining partner. The problem, and when the line gets crossed, is when the school committee introduces a piece of legislation to the legislative body. And that is the issue. And that is what the SERB's line of case.
The answer is, my answer to my question is that would be prohibited, what I just laid out.
That would be,
What I laid out is prohibited. For them to go in, do a warrant article, increase the school budget.
that's
10
the
million.
issue. The warrant article is the conduct that we're concerned
Well, the
about.
facts here are a lot worse than that for the union. But your answer to my question is yes, that's prohibited in your view. Okay.
Wow.
Just
Really? You have a compelling government interest in saying you can't go to town meeting and say, we want you to fund the teachers by $10 million more. Under state law, we can say you must go to the school committee with that. You can't go to town meeting with that.
it's a tricky
That is.
issue because, how specific is your proposal, right? You're throwing out this wild $10 million. I think unions can take a political position. They can write their editorials. They can back their sympathetic candidates. But it gets very muddy when they interfere in the legislative process by writing a warrant, which is
That's
what your
their
example.
constitutional right. That is the core of their constitutional right, to be able to go to the legislature and say, you're not spending enough money on teachers.
Right. But that's different from introducing a specific bargaining proposal.
How do we draw that line, though? What's the standard by which we figure that out? I understand, and as Justice Ditkoff just said, the facts here are really good for you folks, right? because they had tried it a couple weeks before, they'd failed, and then they went to town meeting. But what standards are we applying here?
Well, this is what I was saying before. You can look to the 2009 BTU case and consider the conduct of the bypass, right? And that's when, we find that incidental limitations on First Amendment rights are acceptable in the 150E arena, right? We're not saying you can't wear your T-shirts and you can't campaign for higher wages.
Incidental effects, there are two different lines of analysis, and maybe we're just going to have to take this up with your brother. But there's one way of thinking about this, which is essentially it's a condition that is applied to the fact that we're going to certify you as a collective bargainer. The problem with that is Loudermill and a whole line of cases that talks about whether the government can say take the bitter with the sweet. And then there's another line which just says, well, it passes strict scrutiny, or it passes whatever the scrutiny is.
Right.
Which one do we choose?
Well, I would urge you to choose the BTU standard because I think the bypass is conduct. But even if you apply the strict scrutiny standard, this meets it because the government has a compelling interest in labor peace, and good faith negotiations are inextricably linked to the Commonwealth's compelling interest in labor peace. This is what Branch and Janus talk about, the inextricable link between between labor peace and certain items, for instance, the agency service fees, not inextricably linked, as we know. But instances where, the union's exclusive right to representation, that impinges on an individual's rights to order their relationship with their employer. So there are instances where we have to look at the world of 150E and say, okay, there are some impingements. This is not a blanket prohibition on political speech and your right to advocate. But for the purposes of some common sense, compelling interests in labor peace, there need to be some compromises. And if I could just leave you with this one thought. In overruling Abood and finding agency fees were not inextricably linked to labor peace, the Janus court refers to an absence of pandemonium in the preceding 40 years that they had previously envisioned. Now, the Commonwealth has 351 cities and towns, all with fire, police, teachers, librarians, and other municipal employees. Layer on top of that the massive statewide contracts with all the executive branch employees. If this court reverses the Andover decision and finds bypass to a legislative body on a mandatory subject to bargaining permissible, legislative pandemonium will follow. Every union will have the unrestrained right to seek directly from legislative bodies wages, hours, and terms of condition of employment. This is what the Anderson court foresaw, and they said that it would reduce bargaining to an empty formality and undermine Chapter 150E.
Thank you, Connie.
Thank you.
Attorney Foskett.
Good morning, Your Honor. May it please the Court. John Foskett for the Andover Schools. Let me start off with a statement my brother made at the outset of this case, and that was, this is what the union can do without Chapter 150E in place. The things that the union cannot do without Chapter 150E in place is act as an exclusive representative and negotiate collective bargaining agreements. That is the core of this case. There has not been one agency or court decision cited by my brother in his brief or in his reply brief which says that a union's speech rights or petition rights under the First Amendment trump a state statute that confers exclusive authority on the union, confers its ability to negotiate collective bargaining agreements, and does so in a method that the state specifies. That's the problem here. This is not one case.
You give up your First Amendment right at the door.
Pardon?
You give up your First Amendment right at the door.
Yeah.
You want to be this bargaining agent. There are certain First Amendment rights you're giving up at the door.
Because you don't have a First Amendment right to bargain. That's the issue. What you're giving up is what you're getting, something you don't have under the Constitution, is the ability to enter into a collective bargaining agreement and to act as the exclusive representative. And there isn't one case that supports the theory that that violates the First Amendment.
I guess so, but I didn't see a case that said that that's okay with the First Amendment either.
Well, I guess 50 years of silence speaks volumes. It strikes me as odd that somebody hasn't thought of this. We know that people have thought about First Amendment in the collective bargaining context in terms of the rights of individual employees because we've got 4 Supreme Court cases addressing that. Somehow, this argument...
Because the concept of going to town meeting and doing the end around apparently hasn't been something that's been done a lot, right?
It's been done enough in this state that there are several decisions.
Yeah, nobody's raised it, as far as I can tell, nobody's raised the petition clause issue until now.
It's come up in the California case that my brother cited in his reply brief, the agency decision. They basically said you can't exercise that speech right if you're a certified representative involved on a collective bargaining issue.
And what did the California court say?
That was the California agency. They basically held that on the facts in that case, the union could engage in speech in a forum, but then they clarified that this did not apply if it was exercising its authority as an exclusive bargaining representative on a term and condition of employment. And now, again,
you understand, I said this earlier, but your brother tied into it in his brief. I mean, there are cases going way back that talk about conditioning constitutional rights. And I'm somewhat familiar with the battle, which appears to say that the constitutional rights exist independently of whatever defines the state law.
For example, he cites the Schechter decision by the Supreme Court, which we point out in our brief is not relevant. That was a case where an individual had to compromise their religious beliefs in order to collect benefits.
But do you
That's not the
have
case
a
here.
case where the court has directly addressed this kind of question, which is we're giving you a public right here, the right to be the exclusive bargaining agent, and with the giving of that public right, we're taking away your First Amendment rights. You're losing some. And that's the deal, right? I mean, that is essentially, this is your argument. This is your deal. You want to be the exclusive bargaining agent, you can't do this. And this could be core political speech otherwise, but you can't do it.
If I may respectfully point out, you can't do this in this context, acting in this capacity. However, you have all of these rights outside of this.
Okay, but my question was, is there a case that addresses that kind of paradigm?
No. No, this is not, again, I can only point out that apparently this highly important issue has not occurred to anybody in any of these judicial decisions or agency decisions we have. I'm suggesting a reason for it. And we've cited cases which point out that where there is no constitutional right to collective bargaining, we've cited a Seventh Circuit decision, the state can confer exclusive representation on a union and impose the conditions for how you exercise that.
So take Cleveland Board of Education against Loudermill. The guy is a state employee, right? And he says, I have a property right. And the response from the state is, yeah, and we defined your property right to say that we can take that away from you without giving you pre-termination process. And the United States Supreme Court says, nope, can't do that. Once you've defined the property right, you have to give them the process. It's the bitter with the sweet. And I may well agree that that's not a bad way for government to act, but you've got to, it'd be wonderful if there were some cases, especially in the First Amendment context.
I would have it front and center. What I'm telling you is that there isn't a single case or agency decision which remotely supports this argument. And the reason for it, again, is that the courts have said This collective bargaining area is not a matter of constitutional right. So it defies explanation that if I have no constitutional right to act as an exclusive representative.
What
or to
says
collect-
there's no constitutional right?
In terms of collective bargaining?
Well, there's no
That's-
constitutional right to be a collective bargaining agent.
Right.
But there certainly is a constitutional right to go to town meeting and make and ask for something political.
But there's no, if I may finish, the courts have said there is no constitutional right to collective bargaining. There is no constitutional right to act as an exclusive representative. And that's why a number of states say you can't do it. And the Seventh Circuit has said, when the state does that, they can confer that authority as a matter of statute, not constitutional right. They can say some topics can be addressed and others can't, et cetera. Again,
Those are Seventh Circuit cases, one of your best cases. Which case is that?
it's, I don't have the citation, it's in our brief. We cite it.
Sorry?
Hanover Township Federation,
Hanover Township?
457, Fed Second, 456.
That's an old case.
Yes, it is.
Attorney Foskey, I think we have it. I think we'll have to leave
Okay,
it there.
I appreciate that. And again, if I may say this at bottom, we either have a good faith negotiation requirement or we don't. And if we have one, it's not halvesies. It's the entirety. And if we don't have one, we don't have one. In other words, if the union is dissatisfied with what happened at the bargaining table, enters into an agreement, and then has the right to go to town meeting, we don't have a good faith bargaining requirement. In fact, what we've got is a waste of time,
Thank you kindly.
respectfully. So, unless there are further questions,
Matter stand submitted.
thank you.
Next matter on our list is 24P0287, George H. Wheaton and another versus Ann Coletta and another. Any peace?
Yes, Your Honor. Good morning, Your Honors. May it please the Court, Your Honor, Roger Peace for the the appellant, Anna Coletta. Your Honors, there are two issues before the Court today. And issue number one is whether the Superior Court erred in granting a judgment that ruled against Anna Coletta in finding that Ms. Coletta owed a fiduciary duty to the ward in this particular matter. Issue number one. Issue number two is whether the Superior Court erred when it issued a finding that a trade practice had been going on with Anna Coletta and found her to be in violation of Chapter 93A. I would like to begin with the first issue, if I may address the Court, Your Honor. Your Honor, the facts of this case are quite interesting, to say the least. The reality is, Your Honor, is that this particular person, Anna Coletta, was a real estate agent. She was employed by an agency, Lair Realty. That came out in the facts. What Anna Coletta did...
Employed by the company with her boyfriend?
No, Your Honors.
Separate.
Separate company, Lair Realty. And I'll address that, Your Honors. Anna Coletta had a very close friend because she was married to a gentleman and he had an aunt. That aunt and Ms. Coletta established their own relationship, their own bond.
I understand. And so the aunt said, my brother's trying to sell his property, will you come over and meet him? So that's how
Yes.
she first got introduced to him, right?
That's correct, Your Honor. She showed up at the house, talked to him. He established, and the facts established this, he did not want a real estate agent. He did not want an agent. What she did was, I know investments.
Okay, that's what Ms. Coletta testified to, that's what Margaret Wheaton testified to. Why did the judge have to believe that?
Why did the judge have to believe
Have
that?
to believe that testimony? Why couldn't he disbelieve that testimony?
So, Your Honor, interestingly enough, there was no testimony to suggest otherwise. And I can say this, Your Honor, Miss Margaret Wheaton was his sister-in-law. She was also his fiduciary. She was a power of attorney at the time of
He's
this.
still free to disbelieve it, right?
Yeah, Your Honor, he is free to disbelieve that, Your Honor. However, I think it's important that we find that the court indicated, because Marge Wheaton was also a defendant in this matter, that she did not breach her fiduciary duty. Your Honors, this was a favor. This was a family member who came over and did a favor for someone. I watched testimony of an expert who, by the way, was very knowledgeable, there's no dispute about that, who talked about what a real estate agent does and how they should have these documents signed. The fact of the matter is, the reason why these documents were not signed is because she did not have an agency duty with him. She did not establish that.
Well, she attends the seeing of the property by the buyers. She prepares the offer to purchase. She sends the offer to the parties. She's at the closing. That really sounds like a real estate broker to me. Why can't you find that from that test? And that's your client's testimony.
It is my client's testimony, Your Honor, but it's also my client's testimony that she's not a broker. She was not a broker at the time. And any sort of real estate arrangement that she would have made, she would have had to have done through Lair Realty. Now, my brother connected dots with Ms. Coletta and, at the time, her boyfriend, Ms. Curtis Lanciani. He found a business that they started together. I think it's important to note that the business itself was not listed as a defendant. It was not represented to anyone that this business was involved in this
The difficulty,
transaction.
counsel, is these are jury arguments or arguments to be made to the finder of fact, but you keep running into the same question that Judge Ditkoff asked you off the top, which is, the judge didn't have to believe any of this, did he? Let me ask you this. As to Chapter 93A, your argument is that she was not acting in trade or commerce.
That's correct.
But wasn't there testimony to the effect that the buyers, since she had introduced the buyers into the arrangement, that the buyers expected to use her for resale of the property if it were flipped?
They did indicate that they intended to use her, Your Honor.
Okay, so why isn't that an indication that, at least as to the 93A claim, she's operating in trade or commerce?
Your Honor, it's different here because the allegations are that she was acting in trade or commerce against the interest of Mr. George Wheaton, and that's not accurate.
Well, what was the house assessed at?
There was an assessment of the house of $817,000.
How much did it sell to her boyfriend for?
$400,000. And I understand, Your Honor, where you're going with this, and I appreciate that. But if you look into the matter, and you'll see that in the records, this house was in absolute despair. It had no, it would
Because
not.
the value was the property, right? Not the structure.
The assessment, Your Honor, had a value on it. But again, there is no evidence that suggests that Mr. George Wheaton did not know what he wanted, did not decide on his own. There's testimony, Your Honor, that indicates that Mr. Curtis Lanciani met with Mr. Wheaton.
There's no evidence that Mr. George Wheaton did not know what he wanted? I mean, there's evidence that his sister or his sister-in-law thought that he ought to have a power of attorney, right? And then there's also, as I understand it, there was a deposition taken of him, right?
There was, Your Honor, and that deposition at that time revealed that he was no longer in a state where he could be competent during testimony.
Okay,
That was at the
can it be
deposition.
inferred that perhaps he didn't know what he wanted
Your Honor, I would
from
suggest...
those two pieces
I would
alone?
suggest no, Your Honor, and I can explain why. At the time when that power of attorney was signed, there's no reason to suggest that Mr. Wheaton was not competent to do so. The time frame had been years before this issue was brought before trial. Years. Again, he spoke to Mr. Curtis Lanciani face-to-face, was offered a different price, did not accept that price. negotiated it. Ms. Coletta brought the two parties together. She did not take part in the negotiations. She did not take part in...
She had something to gain, right? She was going to get the listing.
My understanding is that that would have been the goal, but there was no guarantees, Your Honor, and it's still, as of today, not a guarantee.
But brokers do everything with no guarantees. It's still operating in trade or commerce.
Your Honor, I understand that, but again, this is where a broker has a signed instrument that offers some protection. It says if something is signed, that if this property sells, this is what I'm going to get. She didn't do that.
How does a broker get involved in the negotiations other than the way that she did, by preparing the offer sheet and transmitting it between the parties?
Your Honor, as the court's well aware, these offer sheets are pre-done forms. To send an email that fills in the blanks.
But I've bought houses with a broker, and I didn't have the broker go and negotiate the price. I set a price, they did the offer sheet, they transferred the other person brought it back. That's how it works. I don't know what you mean by negotiation if it's not transmitting the offers between the parties.
Your Honor, and I appreciate you bringing that up, Your Honor, but if you made an offer that was different than what the parties were asking for, that would entitle you to some sort of negotiation. In this particular case, that negotiation, that back and forth exchange about numbers did not take place with Anna Coletta. It took place in person between the buyer and the seller. And the perfect example of that, from the example of what we do every day, is if you don't agree to the price that the house is being sold at, you will respond in writing with your offer. This did not happen. The negotiations took place outside in front of the house. Anna Coletta had nothing to do with that. This was a favor. And Your Honors, with all due respect...
So your position is she wasn't representing either party?
My position is, for the purposes of this, Your Honor, she did not owe a duty to Mr. George Wheaton.
Okay, so let's take that aside. Was she the broker? Was she a broker for the buyer?
She was not a broker, period.
She was preparing an offer, proposed P&S, what, as a friend of the transaction? She wasn't representing either side?
So, Your Honor, as I had indicated, that this case is interesting to say the least, because she had a relationship with Mr. Curtis Lanciotti. Again, Mr. Lanciotti was a member of Select Realty, which was the investment company.
So couldn't it be inferred that she was at least acting as the broker's agent?
I'm sorry,
as the buyer's agent? I apologize.
I believe that the court did draw an inference that she was acting as...
And wasn't that a reasonable inference, that she was at least acting as the buyer's agent?
Whether the inference was reasonable or not, Your Honors...
Well, no, it does matter, because then she's operating, if she's acting as the buyer's agent, where she's a real estate broker, she's a licensed real estate broker, she's acting in trade or commerce, isn't she?
So, Your Honor, and with all due respect, we're using the word broker, and there's a difference between an agent and a broker. She's not afforded the opportunity to act as a broker without having a specific license. And at that time, all of her transactions would have to go through Lear Realty. They are the broker that allows the agent to operate under them. She cannot be in her own trade or commerce with regard to selling properties unless she's a licensed broker, and at that time...
She's not supposed to be. Well, she's not supposed to be.
Yes, Your Honor, yes. She's not supposed to be, and I would argue that she was not. These paperwork, all the paperwork that went before her, and again, Your Honors, in the line of work that we do, as an attorney, we make our connections with speaking to people, doing favors, introductions. It is no different. We are the epitome, if you will, of an agency. Yet, we still do favors for people. We are asked questions almost every time we go to a party. Whether that answer is legally binding.
But do you prepare documents for people and then say I'm not their lawyer? I don't owe a duty to them?
Your Honor, I have helped people prepare documents without representing them. I've helped people do a lot of things without taking that step to represent.
In that role, and I'm going to assume this, you're careful with respect to whether you step to the line so that you've undertaken a professional responsibility.
You're absolutely correct.
Yeah.
I am careful, Your Honor. And I can take it a step further by suggesting to this court, because of the ties, Ms. Marge Wheaton is somebody that Anna Coletta considered family. Curtis Lanciotti, obviously she had a relationship there. So that particular bond in my opinion, is the institution of a favor. You make the connection. To help with paperwork is not unreasonable. An inference could be drawn that this was merely a favor.
With respect to the 93A claim, counsel,
Yes.
are you just contesting the finding of in trade or commerce? You're not contesting that there was sufficient evidence to find an unfair or deceptive practice?
I am, Your Honor.
You are? You're contesting the latter as well?
But for the same grounds, Your Honor, for the same grounds. If you're not in the trade or practice, it's going to be awfully difficult to suggest that you violated the terms by acting in unfair and deceptive practices. I do not believe it was unfair or deceptive in this particular circumstance. And I do believe that there's a clear misunderstanding as what an agent and a broker do. But I keep going back to the fact that Mr. Wheaton did not want a real estate broker. He did not want people to do...
Right, but that doesn't mean that her boyfriend didn't want a real estate broker or have one.
That's correct, Your Honor. It
Okay.
doesn't mean that. But again, the fiduciary duty, the argument is that it didn't lie with the ward, Mr. George Wheaton. The unfair deceptive practice is in regard to Mr. George Wheaton in his position regarding that.
Part of that is evidence that's in the record that by the time the matter closed, it closed without the presence of George Wheaton, right?
Yes.
And your client knew that at that point, Mr. George Wheaton had a lawyer, and she didn't tell the lawyer about the closing. All those facts were in evidence, correct?
Your Honor, those facts were presented in evidence, however,
Okay,
counter
well,
to
why isn't that enough to find an unfair and deceptive practice?
Because
We're listening.
Your Honor, with all due respect, evidence also came out that the ward in this matter has another sister who initiated the suit. She removed Mr. Wheaton from the Commonwealth for months. The evidence did come out that attempts to find Mr. Wheaton were fruitless after several months of doing so.
Okay.
That's all part of the non-communication, Your Honor, and that's what forced Ms. Marge Wheaton to come forward and sign his power of attorney.
Does that suggest that he may have been suffering from some dementia?
No, I would think it suggested her sister removed him from the Commonwealth and took control over his finances. That's a fantastic question, Your Honor. She removed him to move him. But I would suggest this to the court. If Your Honor saw the property he was living in, the despair, this is a man who could not clean himself or anything in those living conditions. It was not doable. He could not stay there. And I understand why he needed to move. What I don't understand is why he needed to be moved in secrecy. But that doesn't change the facts here, Your Honor, with regard to what's before the court. With that, Your Honors, I would like to indicate from a practical standpoint that, again, I would ask this court to recognize that when it comes to family, this was a mere favor. There was no unfair deceptive practice, and there was no trade or commerce being conducted by Anna Coletta on her own. This would have been done through Lair Realty if there was an agency connection. Thank you.
Thank you, Attorney Peace. Attorney Dickinson.
Good morning, Your Honors. May it please the Court. Mark Dickinson for Shirley Skaggs as conservator for George Wheaton. Your Honors, this case was tried before Judge Talbot. He issued a special verdict form that was agreed upon by the parties pursuant to Superior Court Rule 20. And so this is exactly like a jury verdict form. And therefore, our first argument is that the standard of review is extremely deferential to the trial judge. And that whatever evidence is in the record that would support the verdict that the judge arrived at should be sustained. And we would argue that the evidence here was overwhelming that Anna Coletta, one, breached her fiduciary duty to George Wheaton, and two...
Okay, let's take that one. What's the overwhelming evidence that Anna Coletta owed any fiduciary duty to George Wheaton?
Okay, so the evidence was, Your Honor, that she was friends of the family. That's what she said and what she testified to, that she was friends with Margaret Wheaton, who is ultimately George's power of attorney. So Marge Wheaton so remember the context here. This was at the height of COVID. Mr. Wheaton was an elderly man living in his long time home without heat, without a working stove, without a refrigerator, where he was in grave distress, and he connected.
So far, you haven't told me anything that suggests that Anna Coletta owed a fiduciary duty to George Wheaton.
So Marge Wheaton brings in Anna Coletta. So the problem is the problem that Anna Coletta is brought into is that George needs to sell his home. Or needs to get out of his home and find a new place to live. Marge Wheaton brings Anna Coletta, as a friend of the family, in to see George. She's traveling, she's regularly bringing George out of his place in Somerville to Marge Wheaton's home in New Hampshire to take care for him. Anna's along for the ride. She sees that George is in obvious distress. She's a friend who's come in, and then she's asked by Marge and allegedly George to help sell his home. So the duty begins when Anna is acting, she's perceived, she's a, hey, I'm a friend, I'm going to help you out, help advise you. I know somebody who can help purchase your home.
So she hasn't assumed any duty at that stage so far,
Well,
right?
at that duty, she's telling George and Marge, I'm going, as a trusted friend of the family, I'm going to find a suitable buyer. So then, what she does is
She doesn't say, there's no evidence she says, I'm going to find a suitable buyer. The evidence is, I know some investors.
That's the evidence that she's testifying to.
Yeah, but where's the evidence? So the judge doesn't have to believe what he hears, but you have to have evidence to establish that she owed a fiduciary duty.
Right.
And I'm struggling with that.
Okay.
I don't see it.
Well,
So you got to help me.
So
Where
Richard-
is it that there's a
it's-
reasonable inference that
So Richard Sullivan was the expert that we had testify, and he's an expert with respect to real estate matters. He's a general counsel at Gibson Sotheby's. He says that the moment that she comes in, Anna Coletta, as a licensed salesperson, acting as a friend or not, she's under a state obligation, acting as
What is her license? I just heard she didn't have one.
No, she absolutely had a sale. That's testimony that she's admitted to. She's a licensed salesperson. She's a salesperson who works for this other unrelated Bear Realty company. But she's there. She's a licensed salesperson. She's being sought by Marge Wheaton, who used her in a real estate.
So is your position that Mr. Sullivan can establish that just because she has a license and she's introduced
No.
to a potential seller, she has a fiduciary duty?
No, because she was being brought in by George Wheaton and Marge Wheaton to consult about
Which was
the
being brought in
property.
by Marge, right?
It was Marge and George. She's a friend of Marge. She's being brought to George. And she's coming as a real estate salesperson.
Let's get to the heart of it.
Well,
And Richard Sullivan testified that the moment that she's consulting about a property or advising about a property in any capacity, that triggers the law, which he testifies is, I can give you a site, it's basically, once she's acting as a salesperson,
Whoa,
And under
whoa, you just jumped over. Why is she acting as a salesperson?
because she's being asked to consult about a piece of real estate.
What if she had come in and said to George, hey, I see you want to sell this house. I may know some realtors. I may know some people who want it. I'll do the best I can to try to hook you up with somebody. Right then, you're saying she...
Yes, the statute,
Assume some duty.
chapter 112, section 87 PP. Any person who assists or directs the procuring of prospects, that's what she was doing. She's asked, get me some prospects, get me some folks that might be interested in buying. That's what she does. She actually goes straight.
What are
What's-
you
what
reading
statute?
from?
What statute? It's Mass General Laws, chapter 112, section 87 PP. This is what our expert, Richard Sullivan, testified.
Forget about the expert for a
Okay.
moment.
But doesn't that require, so Richard Sullivan testifies that just doing that makes you fall in that definition, but that definition requires you to get consideration, right?
No, not necessarily to get consideration. She did get consideration ultimately. She got the listing, basically.
Well, okay.
She's
Any
now-
person who for another person and for a fee, commission, or other valuable consideration does any of the following. That's what the statute says.
In the consideration.
Richard Sullivan doesn't seem to think that's part of the statute.
Well, Your Honor, let's go back. The question you're asking is, how did she get a fiduciary duty? She's voluntarily injecting herself into a situation where she's saying, I'm going to give you my expertise. And the moment she starts drafting and presenting the offer to purchase, the purchase and sale agreement, and she's filling out
doing
these.
that on behalf of the buyer.
But she has to, the problem is, what she fundamentally didn't do here is disclose to George and Marge Wheaton who she was acting for. They thought she was acting for her, obviously, because they entrusted her to
The
fill.
first thing she has to be, for you to win a case of, on breach of fiduciary duty, is she has to be a fiduciary. And the question is, where's the affirmative evidence that she became a fiduciary to George Wheaton? I'm leaving aside the 93A claim.
Right.
I understand that to be a different animal. I understand it to be
She's
different.
presenting herself as a friend and advisor. That's the evidence. By her own admission, she went there to advise him about his options and to help.
So any advisor owes a fiduciary duty?
No. In the circumstances here, I think we have to look at the nature of circumstances. This is a man who's in distress. She walks into a home. She sees that she's afraid to go into the next room. That's her testimony. She sees that there's no working heat, and this is the height of COVID. Man is in obvious distress. He's looking to get out of the property, and she's introduced to this by a trusted friend, George's sister-in-law. So the circumstances Anna Coletta then undertakes to assist George with finding a buyer, and now what'd she do? Instead of doing the normal things that if she's acting as a friend, she was the worst friend in the world, because instead of saying, hey, why don't we list this property on the MLS? Why don't we contact other real estate brokers? She instead runs straight to her boyfriend and says, hey, look at this opportunity. And if you look at the text chain that's in evidence between Anna and her boyfriends and the buyers, clearly she's acting on their behalf throughout the transaction, particularly at all stages. In the negotiations.
Well, so that's problematic. If it's clear she's acting on behalf of the buyers, I mean, that's great for your 93A claim, but doesn't that kill your fiduciary duty claim?
No, because she's essentially an undisclosed dual agent.
You said it was clear she was acting.
Right. Well, it's clear to us when we see the texts. We see these secret texts between them. It's clear to us. But to George and Marge, she's portraying, hey, I'm your family member. I'm your friend. You remember me? I saw you at the funeral 2 years ago. I'm going to help you get the highest and best price. That's what you can infer.
Whoa.
That's what you can infer.
None of what you just said is in the record.
Well, again,
These are inferences.
We rely on inferences because we have what's documented is that Mr.
I think it's a jump from, here is my friend Anna Coletta, to, I'm going to get you the highest and best price for your home. Isn't it?
I don't believe it's much of a jump. When we see that she's being brought, she basically weaves her way into Mr. Wheaton's life by coming to help in a time when she's literally in the car when he's being taken out of his home, going to New Hampshire with Marge Wheaton on these car rides up. She admits to that. So she's driving with him back and forth while he's being taken care of by Marge. And now she's saying, I'm going to assist you, and she admits she's going to assist, and she did. She undisputedly is the one who procured the ultimate buyers in this transaction. She basically injected herself into a situation where she clearly...
Is it fair to say that she injected herself? I mean, Marge was taking her brother back and forth,
Right.
and Ann's her friend who happens to be riding with him. She
Right.
doesn't ask for the listing. She doesn't ask to be introduced to him. She doesn't ask to get involved in this. The sister says, hey, you're in this business, and my brother's trying to sell the house. Would you talk to him?
Well, Marge Wheaton we know for a fact Marge Wheaton ultimately got a power of attorney. They got introduced in March. By June, Marge Wheaton has a power of attorney. So for George. So, and Marge is acting on behalf of George. And I suggest the best evidence of the fiduciary relationship is the testimony of Marge Wheaton. Because when you look at Marge Wheaton's testimony, she says that we went to Anna, we relied on Anna.
She does not say we relied
Yeah, where'd she say
I
that?
think she does, Your Honor. That's the gist of what her.
Give me chapter and verse. I've got some, I read it this morning for exactly this issue.
So, but Marge Wheaton,
Chapter and verse. Where's the page where she says, I was relying on Anna?
I can't do this off the top of my head right now, but Your Honor, that's what.
Okay, well,
the
in that
takeaway is.
case, let's make sure that we make representations to the court that are accurate with respect to what the evidence is, okay?
Understood, Your Honor.
All right. I mean, maybe it's there.
I would
But-
suggest we reread what Marge Wheaton, because when you look at what the gist of Marge Wheaton's testimony is that she reached out to Anna to help with the situation with George. And the gist of Marge Wheaton's testimony is that Anna accompanied her on these drives back and forth. And so.
The testimony was, you weren't relying on Anna? No, I don't rely on people like that. That's what Margaret Wheaton testified to, just the opposite of what you said.
I think that.
Now, you said an argument that rely, but that's not, I don't see that in the testimony.
I think it's a reasonable inference that Marge was absolutely relying on it. Despite what, you can take, she might have testified to that, but the fact is, she didn't turn to anybody else in the world to help with this problem. And so, and ultimately, it wasn't Marge. If you read her testimony, she's very deferential at the time.
Okay, so hypothetically, let's assume that's true. Let's assume that Marge says, and this is her testimony, hey, there's somebody offering $190,000. That would be a disaster.
Right.
I need to get someone else to talk to George, who knows a little bit more about this. My friend Anna brings my friend Anna in. Anna starts talking to George about selling the property. Fiduciary duty arises? And when?
A fiduciary duty arises the moment Anna starts acting as a real estate agent here. And when she starts putting pen to paper for these folks, filling out offers.
Acting as George's real estate agent here.
Right. And that's what she was selling to Marge.
In the face of undisputed testimony from both her and Marge that George said, I don't want a real estate agent. And that's borne out by the fact that he didn't have one. Nobody was paid as his real estate agent in connection with a transaction that happened.
Right. But there's undisputed testimony that George Wheaton was incompetent. We had Dr. Angel testify at trial that right during this time period, in July, this transaction, this went down in May of 2000. In July of 2000, they did a CAT scan, and the guy had definitive atrophy of the brain that documented he had Alzheimer's. So, we're talking about.
When was he deposed?
He was deposed.
I'm sorry.
Probably
When did
a year.
that occur? The CAT scan and
The
that?
CAT scan happened. That's in the record, and it happened in July of 2000. Mere months.
Of 2020.
Of 2020.
So
So
a couple months after.
right. Just a brief timeline. Your Honor.
Before the transaction even
Before the
occurred.
transaction even occurred. Because what was happening here simultaneously is that in May and June, they did the purchase documents with the anticipated closing of July 2000. In the meantime, my client, Ms. Skaggs, comes from Kentucky after the COVID restrictions were lifted, and she immediately gets wind of this transaction and says, this is all wrong. And she starts the process to get a conservatorship, takes him to the doctor, and that, if you look at this is all in evidence, that he was diagnosed with already suffering from Alzheimer's in July when this transaction wasn't even closed.
Thank you very much, Attorney.
All right, Your Honors. Thank you. I submit, obviously, on the rest of the briefs.
Court will take 5-minute recess, short recess.
Court, all rise.
Session be proceeded.
The next matter on our list is 24P0915. Joyce Michaelides as co-trustee of the 3 Dana Ave Trust versus HHC 1 Arnold LLC and others. Attorney McDermott?
Good morning, Your Honor. Attorney Seligson.
Attorney Seligson, okay.
My name is, may it please the court, my name is Damon Seligson. I represent the plaintiff,
It's good. The time is right.
appellant. Joyce Michaelides is the trustee of the 3 Dana Avenue Realty Trust. Your Honors, this is a appeal from a dismissal by the trial court on the grounds that my client lacks standing to pursue her claims.
You call it a dismissal, but it was done at like a summary judgment type of process, right?
That's correct.
Okay. So it was a dismissal after summary judgment.
It was a dismissal under Rule 12b-1, so it had the same effect as a summary judgment dismissal, Judge.
Yeah, okay. Neither Judge Ditkoff nor I are all that wild about the notion that that's subject matter jurisdiction, but we understand that's what the law says.
Thank you, Your Honor. The crux of the appeal is that the trial court respectfully, erroneously dismissed the case under Rule 12b-1 on the grounds that my client was not able to establish standing. The project at issue sits next door to her home. She's on 3 Dana Ave.
The court determined that she had presumptive standing, right? And then they rebutted that, and so it was on her to show a particularized harm. Did she show that?
That is correct. Respectfully, we believe that she can and does.
And so, and strictly to the variance for the parking garage, not to off-street parking, but not to on-street parking, but specifically to the system that they're going to be using for the cars, right?
That's correct, Judge.
All right, so let's address that. Let's be laser focused on that.
So the variances that were granted by the zoning board that are challenged in the lower court are for this underground parking system. You're going to have a project where you've gone from 4 units with 7 beds. Now you're going to have 27 units, 36 bedrooms, adding 27 cars in this system. And the variances are because of the maneuverability and the mechanics of that system.
Okay, and just as we hone in, they offered an expert as to the impact and the effect of that system that was unmet by any expert on her side. Is that fair to say?
That is correct. We challenge whether that expert actually goes in his opinion to what the impact outside of the system is going to be. That's the crux of our argument, was that even though
before you do that, before you challenge their expert, what did you put in that indicates that there's going to be an impact, quote, outside of the system? In other words, as I understand it, your argument is that we're going to be impacted because there's not going to be as much on-street parking.
That's
right,
correct, Judge.
What evidence did you put in as to that?
There is no expert evidence. I'll concede that, and we conceded that at the trial court level. Our argument is that expert evidence is required when...
Hold on. Before we get into expert evidence, what evidence did you put in?
My client put in an affidavit. She put in affidavits from her tenants as to the nature and scope of the street where this project is and where they live, the limited, already burdened nature of this street. It's a one-way street with limited parking already. Traffic is already a problem. These tenants and my client, in the use and enjoyment of their property, suddenly going to have 27 more cars. So the evidence we put in was there is a common
Well,
understanding.
27 more cars parked underground.
Yeah.
Correct. There are going to be visitors to the project, which is already in the record,
But
which will
isn't
park
that-
on the street.
So I think you have to parse this out, right? I mean, the visitors are just because the density is allowed by the Boston zoning ordinance. Are the visitors' cars a valid concern under the case law, given that the density is allowed?
The zoning scheme in place calls for impact to the streets not to be overburdened. It does say that in the zoning scheme. And so this project, which is substantially larger, with this system that gets the variance, is going to bring more of this to the location.
So
And
you
it's not
think
just...
you think that you could win a case to have the variance overturned on the ground that now there are 27 units, there are going to be more visitors?
Well, I think because she's presumed to have standing, that the rebutting evidence from the expert...
Well, she has to be aggrieved, and right? That's the language of the statute.
That's correct.
Okay.
The
And how
aggrieved...
how can she be aggrieved in a manner related to the zoning laws under circumstances where you're complaining? I would draw a distinction between guests who are related to the fact that there are 27 units allowed by the zoning laws, and the zoning law which says you need one parking space off-site for every single unit. So and as to that, they gave a variance associated with getting all those 27 cars off-site, right?
That's correct.
And it seems to me that would be where the focus needs to be, on what happens as a result of the plan and its impact with respect to parking. Am I wrong about that?
No, you're correct in that analysis, Judge.
What evidence is there that addresses that?
Well, the evidence is that she lives at that property. She is aware of what the street's impact is, what her tenants' parking burdens are.
Right, but she says, both Chloe and Joyce say that they discount the rent by $70 a month so that their tenants can park at the MBTA lot, which costs $70 a month.
That's correct.
So since her tenants are already getting private MBTA parking that she's basically paying for, where's the impact?
Well, the impact is that she has to do that.
But she's already doing that, according to her affidavit. She's already doing that already before this project even started. So how is this going to impact her?
My understanding is that she's going to do that, If that's what she will need to do as a result of additional...
She's not presently doing that? I know that she's renting out the spaces in the garage in her backyard for the company with the trucks and what have you.
Because of the lack of parking on our property on Long Dana Avenue, we have had to discount the rent by $70 for tenants in order to cover the cost for them to park at the adjacent MBTA commuter parking lot.
Right.
And I think you wrote this because both affidavits are identical.
She got the affidavits, absolutely, Judge Ditkoff.
Isn't this saying that right now, that before this project, that's what's happening?
And that's going to continue, and that shouldn't have to continue.
But I don't see how you're aggrieved by the continuation of what was happening before the project. Isn't that the opposite of aggrievement?
Well, I think the affidavit that is in the record provides that there is now a need to do some type of a discount, some kind of an accommodation for these tenants.
Is it possible that some of the tenants have been accommodated already and others not? Just looking at paragraphs 23 through 26, they seem to actually be a little bit inconsistent.
My understanding...
23 says, our tenants who need to park their vehicles on the street,
Right.
Which is different than 26, which suggests that they're parking it at the MBTA parking lot.
I think the crux of the affidavits are that instead of having the ability to park on the street, they've got to find accommodation elsewhere. And that is something that is going to be completely...
So how do we get to there? Are you saying that the system that they have, this is just for if they have guests? Is that what you're saying? If they park, if all these 27 people park within the system, in the system that got the variance, and then they have guests, that all of those guests are going to come in cars, and that they're going to need some place to park, and there's not going to be enough on the street. Is that essentially at bottom what you're arguing?
That is a part of the argument. That's correct, Judge. That
calls for a couple of inferences on top of speculation.
I understand the argument that standing cannot be grounded on speculation, but I think there is more to this than just pure conclusory speculation here.
Share it with me.
This is a street that's already burdened with traffic. It's one way, it's narrow. It's already burdened with parking limitations. We're now going to have a sizable expansion next door from 4 units to 27 units. We're going to have additional people parking. We're going to have potentially problems with the parking garage where cars will be on the street. If my client wants to...
When you say we're going to have potential problems with the parking garage, what does that mean?
Well, if the ability to access the underground parking garage malfunctions, where theoretically will those cars have to be looking for space to park?
My understanding is it's a dual system that garages the cars, and that one piece may malfunction, so 7 or 8 cars may have some problems, or the other piece may malfunction, so 8 or 9 cars may have some problems. So we're never looking at 27 cars or tenants.
I understand. I think it is possible that the system might be subject to a malfunction, and that's going to impact things on the street.
The problem is the word possible, which is where the question was right off the top. What is your evidence? Because possible sounds a lot like speculation, which is what Judge Desmond's getting at.
That's as to the potential malfunction, but the actual impact of the use of this new project on the street and on my client's property directly next door, I don't believe is speculative. I believe there is common usage, there is a track record of the street being further burdened, the parking availability being further limited, the remarketability of these units in the future. Now they have to park at the MBTA, as Judge Ditkoff mentioned, comes with a cost. Those are the kinds of impacts that I believe are reasonably, can be anticipated.
And those are particular to her?
Well, they are particular to her.
Not to just everybody else who lives on the street?
I think there's a combination. It does affect the general community, but doesn't mean that it doesn't affect her in a particularized way. So yes and no, Judge, respectfully. I believe that it is a particularized harm. And I understand the cases. The cases say a generalized neighborhood harm is not enough. But this is a particularized harm towards her. And so that was the reason for the underlying lawsuit. And when the presumption of standing was rebutted, the traffic consultant hired by the appellee doesn't mention anything about traffic. He mentions that it won't have an impact on garage operations or street operations. Doesn't say anything about traffic or parking or the neighbor next door. And so for those reasons, we believe that they have not rebutted the presumption. I'm running out of time, but I do want to address one argument that my brother counsel raised, is that there's some kind of ulterior motive, and therefore it should tie into some type of a 231(6)(f) claim for bad faith. This is not brought in bad faith. My client has lived there since 1984 and now has a significant project next door and is concerned about it. She's raised legitimate, meritorious arguments. They're not done in bad faith. They're not frivolous, and I'd ask that the court deny a request for some kind of an award as a result of that. There is ancillary litigation about an adverse possession claim along the property line. The two are separate events based on the same location. Thank you.
Conley. Now we will hear from Attorney McDermott. I think I got that one right.
Good morning, and may it please the court. My name is Michael McDermott, and I am counsel for HHC 1 Arnold, the recipient of the variance decision from the Boston Board of Appeal, and the owner and developer of 7 Dana Avenue. This case pertains to the standing of an abutter that owns a multifamily and commercial property at 3 Dana Avenue.
What's our standard of review?
The standard of review here, because this is for the factual questions, we have deference to the factual determinations by the lower court. To the extent that there was a question of law as the basis, that is de novo by this court. Here, the majority of the findings are findings of fact, which go to whether or not there was sufficient objective evidence put on by the plaintiff as a basis for their standing, whether or not that evidence showed particularized harm, whether that evidence showed a causal link to the zoning relief that was granted. So for those are findings of fact that have been ruled on by the Superior Court through a 12B1 motion to dismiss.
So let me ask, is Marashlian still good law?
Yes, that's still considered to be part of the precedent.
Why isn't that the end of this case, from your perspective? I mean, the plaintiffs claim to fear increased traffic and decreased parking availability due to the defendant's development of the lot. Such concerns are legitimately within the scope of the zoning laws. The judge found that the hotel project will result in minimal increase in traffic and a decrease in the number of currently available public parking space. Finding is supported by the record. Why doesn't Marashlian just take care of this?
Your Honor, from the section that you just read there, we begin by looking at whether or not it's a legally cognizable harm. So there, that began as a question of law. That's one reason that this is distinguished from Marashlian, and that we do not have the zoning protected interest, the zoning relief as the causal link for the number of vehicles coming to this property.
I don't get that. We have a zoning bylaw that tells you how your parking has to work, and you get a variance from that. And why isn't the effect on street parking within the zone of interest in a zoning bylaw that says you have to have so many parking spots and they have to be maneuverable and they have to be useful?
So there's two different parts of the zoning that gives rise to off-street parking. The first is the number of spaces. That's a relationship and a ratio between the number of units, which was as of right here, and the number of spaces that were being provided through off-street parking. Again, as of right and dimensionally compliant. So when you have a question of the number of vehicles that are coming to the property and where they are going to park, there was no zoning relief that was provided. Then there's the second question, which is
Well, is that true? I mean, do you really have 27 spaces?
Yes, Your Honor.
And that's as a matter of law? Because you just presented it as a matter of law.
So as a question as to counting the number of spaces for a ratio back to the number of units, that did not require any zoning relief and was determined to be as of right, and the 1-to-1 ratio that's required by Table F, footnote 3 for Article 69 of the Hyde Park neighborhood.
Determined to be as of right, even though somebody raised their hand and said, hey, you got to show us that this thing works?
And that comes to the question of maneuverability. So within the zoning code, there's the...
Well, but you're parsing this pretty thinly for me, okay? Because what I see is you have 12 parking spaces, and then you've put 13 on top of the 12, right? Or 14 on top of the 12. You have 12 parking spaces. You can put 12 cars in there. If you want to put 26 cars in there, you're going to have to put the other 14 on top of the 12.
So with regards to the...
And somebody said, not so fast, you need a variance for that. Because you don't have 27 parking spaces. You've got 12.
Well, Your Honor, the definition of the parking space is both the number of spaces and then the dimensions of that parking space. That is governed by the maneuverability provisions of the zoning code. That's correct what the zoning relief was needed for. And so the question, as provided by the zoning, is does that maneuverability within the garage, the way these parking spaces are laid out and designed, and the technology used, does that have an impact on the street operations on the public streets surrounding this project site? For that, an expert was hired by
Right,
HHC.
but that's within the interest, right? If your parking doesn't work because it's not maneuverable, it's going to have an impact on traffic, it's going to have an impact on on-street parking, and that's within the zone of that interest, right?
So when we get to maneuverability, yes, that is correct. And so there we look at the objective evidence. Here, there was a presumption of standing, which requires the defendant to come forward with facts that are contrary to that presumption. It doesn't have to disprove the presumption. It doesn't have to prove that this will or will not occur. It needs to come forward with credible evidence
Right,
that's
and
contrary.
there's nothing in McKinnon's affidavit that talks about on-street parking. Nothing at all. It just says the project will not have any, it has stuff about traffic. The project will not have any impact on garage or street operations. But it doesn't say anything about how it affects the parking on the street, what the parking's like on the street. I don't see that.
The affidavit says that this is a technology that's in common use, that is highly regulated and regularly maintained, and that it will not have an impact on street operations. So looking at the fact that their theory is that this is not a maneuverable system that could hypothetically break down in the future if not regularly maintained, and if independent actors are unfamiliar with this technology, they may then go park on the street. The affidavit and the supporting report provides facts contrary to that theory.
It seems like their theory is your project's going to cause more people to park on the street.
And for that, again,
the affidavit doesn't say otherwise, does it?
Because the affidavit says that there's enough parking required in the one-to-one ratio for a system that's commonly used and for something that will not impact street operations on the surrounding streets, the defendant's burden of rebutting the presumption has been met. Because even with the presumption of standing, the burden of proof always remains on the plaintiff. The presumption requires a defendant to first put
Only
forward-
if you rebut the presumption, though. If you don't rebut the presumption, then standing's established, right?
Standing is presumed to be established, it can be raised at any time, but moving forward, it has been presumed to be established. So here, there were a number of different ways that that presumption was rebutted. One was the causal link, that legally cognizable and causal link argument that the ratio being as of right means that they have not surpassed that first step. The next was that there...
That doesn't go to this problem that Judge Ditkoff's talking about. I mean, the on-street parking, isn't that directly related to the question of whether you have sufficient off-street parking?
That is one way to rebut the
Is that a
presumption.
causal relationship? You have to have sufficient off-street parking so that you don't impact on-street parking. And that means you needed 27 spaces. And you say, well, we succeeded because we have, actually it was wrong, you have 12 spaces and then you got these other 2 spaces for handicap parking, and then you have 14 spaces up above. And how does this work? The people have to drive into the lot, they have to back up. Is there only one space that from which you can be hoisted, or can you be hoisted from any of the spaces?
So the way that the system works is one is designated as the space where you pull into a slide, and then that moves up and over. This is from the professional traffic engineer's report and explaining how the system works. It's the slide system. So at any...
So I pull in, I'm going to pull in, I'm going to, and there's only room for, looks like one car to be doing this at a time. So the car pulls in, it backs into the one space on either side from which it can then be hoisted up, and then what do the cars like rotate around like this?
They don't rotate around, but they can slide around. So one can drop down in a child kind of
And then
moving game where one moves down and one can move over.
when they drive out, do they only drive out of that one space? Or can they drive out of any of the spaces?
Whatever space platform that vehicle was placed onto is the one that they would drive out. So they're driving in and out of the same platform. The platform moves that they are parking on.
No, I got that part, but does that platform have to come back to the space closest to the front entrance before I can drive my car out?
It does not necessarily have to come back. It could be in the center of the 5 across spaces. and so then they could move out from there. It's where that vehicle is going to be lowered back down to ground level.
And is it one at a time? Let's say 6 people return back to the building in cars at the same time. Are the other 5 cars waiting for the process to go for each one car individually before they can?
Well, the two systems could be working simultaneously on moving cars, but
I got to tell you, that's not in your expert's report, that they can work simultaneously. And I'm looking at the design, and there is no way you could get 2 cars in there backing in at the same time.
so the question for vacating, the 2 cars could be being lowered down to the ground. There's only one entrance and exit ramp to this facility, so any car parked on the ground or in the system would have to leave one at a time going up that ramp and out of the system. The expert describes, as part of the report, I believe this is at Record Appendix, page 1, pages 158 to 159, that's the area where his report is, and his affidavit, he describes that the time that a vehicle would be using the system is forecasted to be every 4 to 5 minutes based off of his expert review of the system and his knowledge as a professional traffic engineer.
Where does he say 4 to 5 minutes? That's interesting.
So that's on, I believe that's page
157?
157 of Record Appendix 1 at the bottom of professional engineer and professional traffic engineers Ian McKinnon's letter. It's the last paragraph where he describes the vehicle.
But that's based on the volume, the assumption about how many vehicles are going to be coming in during peak hours. Every 4 to 5 minutes, you'll have somebody coming in. That's not how long it will take to operate the system. He suggests it'll take 40 seconds.
Correct. So the service time.
More than 40 seconds for me to back into a parking space like that, I got to tell you.
Yes, Your Honor. Again, he describes that this is becoming a more common system. These are typically for the residents of the building who would be able to use it. And so.
But if the residents don't want to use it because it's hard, where are they going to park?
And so there, Your Honor, that theory is the type of speculation and conjecture that requires objective evidence put forward by the plaintiff, which is the failing here, the lack of that evidence. So what we know when you come up with independent third-party questions and hypotheticals of future events is those cannot be a basis for standing without objective evidence being offered on those points. Both the Supreme Court and the Commonwealth of Massachusetts Supreme Court.
I think there's a case that says, because I had a case just like this a couple months ago, that expert testimony is not required with respect to traffic issues, right?
There is a case that says that.
Common sense is something that can be used as long as it's not too speculative.
In limited circumstances, Your Honor. So you're referring back to Marashland, which is a case where an expert was not required because the plaintiff was able to look outside at the amount of curb space and then look at where the driveways and curb cuts would be and delete those as parking spaces on the street to come to a calculated number of the loss of overall parking space on the street. That was a purely mathematical question for which an inference could be taken, and no expert was required. However, when you turn to the question of how vehicles will interact with systems or interact with each other on the street, or points of intersection, conflict points is what they're called, there the case law is quite consistent that this is an area where expert testimony, both for traffic and for parking, is required.
And what case would you point me to as being the best case for, or one or two cases, the best cases for saying, okay, even though you're in a butter and you're raising traffic concerns, you have to have expert testimony to address that question, or to address the question in the context?
Yes, so in October of this year, the appeals court, or of 2024, the appeals court issued a decision in Whittier versus Planning Board of Ipswich.
I should know that case. What was that about?
That was about the construction of a hotel, conference, and office system for a biomedical pharmaceutical facility in Ipswich. There were questions as to vehicular safety and horse safety and driveway conflict points on the road. There actually were experts provided by both parties. In that decision, they talked about why there was a need for experts and why at 12B1 it was appropriate for the court to still find that there was no standing as it pertained to traffic and parking.
Let's say you're right, you need an expert. Where does your expert say there'll be no effect on the on-street parking?
He did it by saying that there is sufficient parking provided, that there will be no impact of street operations, and that this is a system that is commonly accepted throughout the United States for parking in these type of residential buildings.
Why-
That's sufficient to rebut the presumption.
Why do any of those things equal no effect on street parking?
Well, again, Your Honor, the question is whether there were facts put forward contrary to the presumption. It's the plaintiff's burden to put on objective, credible evidence that there will be an impact.
Well, the
on street
plaintiff
parking.
says, plaintiff's the butter, the plaintiff says, street parking is one of my impacts, and now you have to come up with evidence that street parking won't be impacted, and if you do that, then the burden shifts back to the plaintiff. Where'd you do that?
So, Your Honor, we did it in 3 different ways. First was the causal link related to the legal argument. That's one way that standing can be rebutted. The second is the expert witness as objective evidence putting forward an explanation of the 1-to-1 ratio, the system itself, and no impact on street operations. The third is going to the particularized nature of the plaintiff's harm, saying that they have not shown any particularized harm here. They are making a claim in their affidavits in paragraphs 23 through 26, which is the same as everyone else in the neighborhood, that they've observed an existing condition, that there's a competition for parking in this neighborhood that's general to everyone.
Really, you can't, so that one bothers me because it sure seems like if I live next door to you and I presumed to be, to have standing, to presume to be aggrieved, and my concern is you're going to need, you're going to have 23 more units, and some of those people are going to be parking really close to me, which means I'm going to have less. You're saying that's not particularized because it's a concern of the entire neighborhood, not just of me?
I'm saying,
even though they're next door?
first I'm saying that the number of units is irrelevant because it's an as-of-right number of units. So that density question had no relationship to the zoning relief.
And I understand that argument. We're not talking about that. I'm simply talking about the fact that 23 more units. So that's, even by the zoning code, 23 more spaces are needed, right?
Correct.
Okay. You're saying, well, that argument doesn't work at all under the case law because that's an argument about an unparticularized harm. The entire neighborhood is going to suffer. If any more cars have to park on the street, the entire neighborhood suffers, not you particularly. That's your argument, right?
That's one of the arguments, yes. And the reason...
How can that be when they're next door?
Because, Your Honor, there's a number of properties that are all next door.
There'll be 2 and then maybe 2 across the street.
These are plaintiffs that have 2 different curb cuts. They park their cars in a driveway. They rent out the commercial spaces as a business activity in their rear yard. And
yeah, but they have affidavits that say our people are going to have to park on the street.
they have affidavits that their tenants do park on the street, but they, again, don't get to that next level of providing any objective fact, any credible evidence that explains why those spaces in direct proximity outside or next door to their property are theirs compared to anyone else's in the neighborhood, or are used as theirs in any magnitude that's different than those in the rest of the neighborhood. So there's that lack of particularized nature, bringing them back to a general, similar use of the street as to all the other neighbors. I see that my time is up, and I otherwise refer to my papers.
Is that the end of the answer? Is that the end of the...
For a particularized nature, yes.
Anything additional? Thank you, sir. Matter stands submitted. Thank you both.
Your Honor, the city had reserved 1 minute.
Right. Did they split their time? 1 minute. Oh, yeah. Attorney Bardsley.
Yes, Your Honor. Good morning, and may it please the court. My name is Jeremy Bardsley. I'm here on behalf of the Zoning Board of Appeals for Boston, and I understand my time is very limited, so I'd just like to give you the opportunity to ask me any questions you have, and also just circle back to what I think was the laser focus you spoke about at the beginning regarding the particularized harm here, which I think on the briefing we've covered thoroughly that there is none on behalf of this particular.
Why not?
In this particular case, she has off-street parking access, whether or not it's currently rented out or otherwise. I think the case law is rather clear that if off-street parking exists, then in those cases, there is no standing for a complaint regarding
The argument, that argument is that she has to use what she currently rents to a different tenant for a different purpose, she has to use for her tenants. That's that argument, right?
Right.
Why would that be? Why wouldn't it be an aggrievement on her part? She rents a whole piece of her property currently for commercial purposes. Why isn't she now aggrieved if her tenants who use off-street parking, according to the affidavits, now are going to have a harder time getting off-street parking because the person next door just added 23 units?
Well, I think a directly relevant case would be the Tropical Faye one, where there was a parking lot for I believe it was a grocery store, where there was found to be no standing for the parking lot to complain, despite the fact that, spots that would otherwise be taken up by their tenants were complained of the potential possibility in the future of being utilized by the nearby project that was being built. So I think there is a direct correlation there, but I do understand your point that it's not necessarily the same if there is a specific spot rented out, but there is a rear yard full of.
But isn't that a particularized harm? The money that she may have been making because she was able to rent it out to this commercial.
It could be, but I think here there's no credible evidence suggesting that. I mean, she has a personal affidavit, but
That's not
Right,
correct.
I don't understand. I thought you said she's supposed to kick out the commercial business and let her tenants park there, and that's why she's not harmed. Now you're saying she doesn't do that?
perhaps I
Is it?
misspoke. But the point I was trying to to make is that where there is alternative parking, generally, I think the court has been clear that those should be taken into consideration when analyzing whether or not.
What's the alternative parking here?
Here she has off-street parking for both tenants and also for commercial tenants. So while she does indicate some tenants may park on
Well,
street.
it seems like she's got two spots for herself and Joyce, Chloe and Joyce, and the tenants all have to park on, there's no parking for the tenants I can see without
I apologize. I was
expelling the
referring
commercial.
in total to the residents rather than the tenants, so inclusive of herself.
How about this?
Wait, so where do people get to park? You said they don't have to park on the street, and you're going to tell me where they are going to park, if that's true. Where
Well,
they're going to
Your Honor,
park.
I think what I'm getting at is that it's not particularized because that is more of a generic neighborhood harm regarding on-street parking. But in this case, while she does have some off-street parking, there are, I think that just makes it a bit different than as my brother has indicated in his briefing today for
She
the
has
court.
some off-street parking. That includes what, the garage? Does she have a garage and the back space? Or
I believe
just-
so, yes.
And a driveway. But she says, my tenants park, some of my tenants park on the street. At least that's the way I would read the affidavit reasonably. This is outside the record, and if you're not comfortable answering it, don't. But this stacked parking, is this something that's a thing? Is the city seeing a lot of this?
I don't know that the city's seeing a lot of this, but I think it is becoming more commonplace. It is all over the world at this point. I think Japan has, in particular, made some particular leeway in moving forward with this. So I would say it's currently rare in existence here, but it has become more and more commonplace to the point where I'd expect it becomes more of a factor to
You say
fit more
rare
parking in.
I'm sorry, when you say rare in existence, here in Massachusetts or here in the US? Where are you saying?
I think here in Massachusetts. But again, I don't have a lot of information specifically relevant to give you numbers or figures.
Thank you. Matter stands submitted. Final matter of the day is 24P0507, Commonwealth of Massachusetts versus Hockney. First name. Attorney Loeb.
Yes. Good afternoon, Your Honors. May it please the Court. My name is Jeffrey Loeb. I'm accompanied today by my associate, Jonathan Loeb. Together, we represent the appellant, Che Pocknett. This is a case out of an appeal from the Falmouth District Court and then the appellate division of the district court. An appeal of denial of a motion to dismiss, and then ultimately a grant of summary judgment.
So, it's an appeal of what? It's an appeal of what?
Denial of a motion to dismiss.
Where's that? Where can you point to me where you appealed the motion to dismiss?
The notice of appeal, Your Honor, was broad enough to cover both of the orders that were entered down below.
I thought I read that the notice of appeal was to the decision that was rendered on November the 20th.
I thought it was broader than that, Your Honor, because it encompassed.
Point to me, show it to me.
I will have. I'm going to have to go back. That was the one, I didn't look at that in advance, Your Honor, and if I've misstated, then I will limit the appeal to the summary judgment. I thought what we wrote, Your Honor, was we appealed the judgment that was entered that day.
It says the appeal is to the decision that was rendered on November the 20th. The decision that was rendered on November 20th does not speak at all to motion to dismiss, strictly to summary judgment.
And if that's the
Unless
case,
you can show me something else, which I'm happy to look at.
Your Honor, I will move on. If that's the case, then, because I think the issues are all intermingled, that's.
Now, at bottom is the concern or the point that you're making that sustenance means more than just feeding your family. Are we talking about the definition of sustenance?
That is ultimately the issue, Your Honor, that sustenance is more than food. And the the Falmouth District Court.
And you think the legislative intent encompassed sustenance being beyond just food?
Actually, I think, Your Honor, it's more than legislative intent. I think from a reading of it, that the case law makes it clear that it has to be read in a way that is favorable to the Indians, and that there is no definition. And so we now go to
But the word sustenance isn't in either a statute or really the case law in any way that makes it the word that we care about, is it?
Well, I differ, Your Honor, because it does talk about the 1982, I believe it is, legislation talks about the ancient and aboriginal claim of Indians within the Commonwealth to hunt and fish the wildlife of this land for sustenance of their families.
Wait, you're not reading from a statute?
That's
What statute are you reading from?
It's the 1982, I believe, resolution, Your Honor.
Oh, it's a resolution.
Resolution. That's the last piece of
So
legislation.
that says, as a source of food for the sustenance of their families. The resolution.
No, what it talks about was, Your Honor, it talks about the hunt and fish for sustenance of their families.
But you're reading from a resolution.
Which is where on the point to in the record, please?
That's what I'm about to turn to, if I may, Your Honor.
Because the statutes say, provided that nothing in this act shall extend to deprive any native Indians of the privilege of digging shellfish for their own consumption.
And of course, here, there's been no action or libel as against those oysters that Mr. Pocknick harvested that day for his family. My understanding is he had 1,600 oysters that he harvested and sold under his commercial license and tagged and bagged and all those things that you have to do. And he had another batch of oysters, I don't know the number, that he kept for his family, to which the Commonwealth took no action. Is that right?
That is correct, Your Honor. I'm trying to, yes.
See, I think it's really important, if you're going to frame your entire argument around the word sustenance, that we know where the word sustenance
Well, I will
comes from and
point.
why it's, let me finish, and why it's legally operative. Because I went back and I looked at the statutes, and I just read you one, for their own consumption, for his own family use, which is not the same thing as sustenance. But, by the way, the case law, because I'm looking right at it, Commonwealth against Maxim, it seems to equate the word sustenance with the word for their own consumption.
And I differ, Your Honor, on that last phrase, because it is Maxim. Maxim is, as far as I know, it's the only case that's out there.
So here, just help me with this then. I'm reading now from sustenance. I'm reading now from Maxim. The defendants cite a long history evidencing legislative and executive recognition of their aboriginal rights to shellfish for sustenance. Cite the statute from 1795, provided that nothing in this act shall extend to deprive any native Indians of the privilege of digging shellfish for their own consumption. It seems to me that the Supreme Judicial Court, when it used the word sustenance, meant for them to eat.
I would differ.
That's the only place that I'm really that familiar with the word sustenance. You say it's also in not in a statute, but in a proclamation.
It's in the proclamation as well, Your Honor, because I quoted that as I was pulling it together for this argument. I differ with the court that what the court in Maxim said, and at no time has the court ever said that fishing for sustenance is limited to personal eating. That's not what we're talking about here. That's not what
You say personal as to Mr. Pocknett, or do you mean personal as to he and his family?
I would include, Your Honor, within the family, but the key is in terms of the fact of eating. That when we talk about what is sustenance, sustenance is considerably more than food. Sustenance is shelter. Sustenance is broader.
If sustenance is the operative word, you understand my point?
I do understand your point, Your Honor. That I would agree with you that sustenance is the operative word here.
No, that's not what I'm saying at all. I'm saying the opposite. I'm saying sustenance is not the operative word. I'm saying the operative language is either language in a statute or in case law.
I just have to pull the line that I had, Your Honor. And I would say that the line in the case law that the appeals court and the SJ, neither the appeals court or the SJC in Maxim ever define what it is, what right in terms of usage that a Native American has.
If you're right, I'm going to just move from my first point to another one. If you're right, and sustenance has this broad, and Native Americans have the right to fish or shellfish for sustenance, and sustenance means basically my job by which I provide for my family, which it seems to me is the way you're arguing this, then what is the government able to do in terms of regulating Native Americans when they fish or take shellfish, if you're right?
Actually, with the Native American, the law makes clear that
Do you understand my question?
I understand your question precisely, Your Honor, that there is very little that the government can do in regulating Native Americans when they're fishing.
Okay, so why isn't it that we only have Native Americans fishing off of Stellwagen Bank? Because now there can be no restriction on how many fish they take.
What I said, Your Honor, is there is very little, and there is very little. We've had very little here. There's been extensive litigation in Washington State on this point. That the state had to come back to some of the constitutional issues Your Honor heard earlier today. There is very little that the government can do in terms of regulating what Native Americans can do in terms of fishing for sustenance. Fishing for sustenance in the broad way you want to define it, which is basically to make money.
And so you're saying there's nothing they can do. They can fish whenever they want, and they can sell it whenever they want.
No, I think it's going to become
no oversight.
No, Your Honor, and that's not what the law is across the country on that point. That there are limits in terms of what a government can do. The issue here is, can the government say that Mr. Pocknett, solely because he happens to be a licensed commercial fisherman license, that therefore on a day that...
That's not what they're saying. So that's wrong.
Well, no, that's why they cited him, because
they cited him not because he had a commercial fisherman's license, because he needed to use his commercial fisherman's license in order to sell the harvested oysters.
No, I disagree, Your Honor, that he needed to.
Wait, hold on. How can you disagree with that? Big Rock Oysters is a permitted wholesaler, which by law can only accept fish from people who are commercially permitted to fish.
Right, but they only pulled him because he had pulled those oysters from a location that Falmouth doesn't permit commercial fishermen to fish on that
Tuesdays.
particular day of the week.
That's what drew their attention to him.
On that particular day of the week. That the fact that he went to the wholesaler is not necessarily dispositive.
Well, I don't
He fished
understand.
elsewhere.
But the only way he can go to the wholesaler is if he's using his commercial fishing license, right? That's what the regulation says. It is
Yes.
unlawful for dealers to accept any species of fish from persons not commercially permitted. But if he was out there on the street selling his oysters, that would be one thing. But the only way he can sell to Big Rock Oysters is by using his commercial fishing license, right?
Yes.
So he was using his commercial fishing license.
Well, I have to retract that.
Okay?
I thought that was
How
undisputed.
do you retract that?
No, it's just the breadth of Justice Ditkoff's question, that the Mashpees have their own fishing operation, and so he could have conceived, in that hypothetical, in terms of the justice's hypothetical, that's
Well, I
all.
mean, it would have been interesting if they tried to cite him if he was selling through the tribe's policies, but he used his commercial fishing license to sell to a permitted warehouse.
This is an action in rem. This is against the oysters, right?
Yes, Your Honor.
Okay.
It was an action in rem following the warning that was given, but yes, and the question, though, that I maintain is to what extent that was commercial as opposed to non-commercial. That you have a situation.
So how was it? What do you point to that it was non-commercial, other than he had some Aboriginal rights?
Oh, the answers to interrogatories that are laid out, they're in the record.
Tell me.
I'm going to give you the page number, Your Honor. I believe it's page 139 in the appendix.
He used his license to sell them. He bagged and tagged them in a way that was compliant with commercial fishing.
Yes.
Right?
He did all of that. What he said in his answers to interrogatories, and it's also in the statement of material, in the denial, or in a response to the statement of material facts, that he maintained that he was not fishing commercially at that time, that he was fishing for
Just
personal.
because he says it so doesn't make it so.
But it creates I would agree with Your Honor at a trial. I would absolutely agree with Your Honor that had there been a trial, that had the Commonwealth presented their evidence and Mr. Pocknett presented his evidence at the trial, the fact finder could have said, I'm sorry, we don't find that to be so. However, at the summary judgment stage, that's an issue of material fact.
How could any reasonable fact finder find that he was not engaged commercially, using the word commercial, right, which is the word, by the way, that's in the statute, okay, when he took $480 for giving them 1,600 oysters, and he bagged and tagged them in the way he was supposed to as a commercial fisherman licensee?
Because, Your Honor, there was at least a toehold of an issue of fact.
Which is what?
What is it?
That you have, for the fact finder to make the determination, then they are absolutely ignoring Mr. Pocknett's testimony. And you can't do that at the summary judgment stage.
You can, if you look at it and you say no reasonable fact finder could find, if he makes a statement, I wasn't fishing commercially, okay, which isn't really factual because it has a legal component, that doesn't have to be accepted
What he said
by a
was
finder of fact.
he was fishing for, he said he was fishing personally. Let me
So
give you
if Big Rock Oyster accepted these oysters not from a commercial fisherman, aren't they still forfeitable?
I'm sorry, Your Honor.
If Big Rock Oyster accepted oysters from a non-commercially licensed fisherman, which you're saying he was acting as, aren't they still forfeitable? Can't the government still forfeit them? They've been transported, held in violation of law by the dealer?
Because the only violation was the regulation did not permit commercial fishing on those 3 days of the week.
But if your defense to that is there's a totally different violation that makes them forfeitable, why would that defeat summary judgment?
I'm not
The
sure.
government's theory is that he's a commercial fisherman and he took them when he wasn't supposed to. And you say, no. He wasn't acting as a commercial fisherman. Big Rock Oyster was illegally buying oysters from someone who wasn't acting as a commercial fisherman, which would still make them forfeitable. So why is that a summary judgment defense?
We did not make,
Well, I don't see what the options are. Big Rock Oyster can only accept from a commercial fisherman. So either they're acting illegal, either these oysters are illegal when they take them, or they're illegal when they're handed to them.
we do point out the fact that Big Rock Oyster is not, there's no claim brought against Big Rock Oyster, and one can question that. So
Right, because the only claim is against the only claim is against the oysters. This is an in-rem action against the oysters.
And what we're saying is that those oysters should not have been, yes, that you could bring the in-rem, but in order for the finding to have been made, there had to be a finding at trial that this was in fact commercial. The cites, and that's what I was thumbing through, it's at pages 139 and 157 in the appendix.
But if they're not commercial, why aren't they still forfeitable? Because now you have a licensed warehouse, a licensed wholesaler who has non-commercial oysters
They
illegally.
wouldn't have been forfeitable by my client.
But it doesn't matter. We forfeit the oysters. The oysters get forfeited.
But the value, what appears from the record, Your Honor.
We want the 480 check.
What appears from, yes, but what appears from the record, to answer this, is that the value that would have gone to Mr. Pucknett was forfeited. Big Rock, however, was permitted to sell the oysters and to keep whatever proceeds it earned from that sale. To answer Your Honor's question, if a forfeiture proceeding could have, under your hypothetical, I would acknowledge, a forfeiture proceeding could have been brought against Big Rock if it was found that Big Rock acted improperly and that Big Rock would have had to forfeit whatever money it received. That's not what happened, though.
Can I, because you're out of time, but can I ask, I did not see you make an argument that the only thing that was forfeitable was the oysters, not the $480 that your client got in a check. You didn't make that argument, right?
No, because the claim is the value, the forfeiture claim is the value.
And
I would acknowledge that.
There's case law that says that's appropriate.
Yeah, I would acknowledge that. The only thing I would say is that where there's an issue of fact and we hadn't raised it, the Commonwealth in their brief talked about the fact that it's only the profit. And if that is the case, there was no evidence as to what the profit was. And so again, that would create yet another issue of fact that should have not.
Where is this, that that Big Oyster sold the fish? Where am I going to find that? The oysters?
That is in the Commonwealth's, it's either in the motion to dismiss, Your Honor, or in the Commonwealth's brief in the motion for summary judgment. I don't remember specifically which memo that's in, because that would have been in facts that the Commonwealth would have had.
And you're saying in that, the Commonwealth has asserted that they went to get the oysters at Big Rock and learned that Big Rock had sold them. Is that what I hear you say?
No, what they did was they went, I think, within a matter, my memory of the chronology is they went within a matter of a couple of days. They very quickly did that, put the value on it, but the facts, as I understand them, as was laid out, I wasn't involved at the trial court level, that Big Rock was permitted to sell the oysters. To come to Justice Englander's question, what happened to the oysters? Big Rock was permitted to sell those oysters.
And again, at bottom, your position is that $480 that he made, you want to say traded, but sold, was that money was going to be used for the sustenance of his family?
Yes.
To help in whatever ways he was going to help?
Yes.
I think we got it.
Thank you.
Attorney Reynolds for the Attorney General's office.
Yes, thank you, Your Honor. Mr. Parknett's membership in the Mashpee Wampanoag tribe is not a defense to the libel action, primarily because he acted, as you seem to understand, in a licensed as a licensed commercial fisher.
So Attorney Loeb says, yes, feeding his family with those foods is sustenance, but using that money to pay for their shelter and to pay for electricity and what have you is also sustenance.
So I have two answers. The first is that this is not a case about Aboriginal rights, so I don't really think that you get to sustenance. But if you do get to sustenance, we say that it means basically food and drink. And I can explain
what do you point to for that?
Okay. So as long as I just want to be clear that we do not believe you reached that issue because it is undisputed that he acted as a commercial fisher when he sold the fish, because he presented his credentials as a licensee. He didn't present his tribal membership card. Okay, so but relative to sustenance itself, it's not in my brief, but one statutory reference I can provide to the court to help define or clarify that sustenance does mean food and drink is in General Laws, Chapter 272, Section 77. It's a statute I found when I was preparing for today.
I'm sorry, could you get that to me again?
Yes.
Chapter 272, Section what?
272, Section 77. It refers to depriving an animal of necessary sustenance. It was a statute that the SJC reviewed in a case recently. So, and I think that in that context, which is it's a very it's a statute currently on the books. And plainly, to deprive an animal of necessary sustenance can only mean food and drink. It can't mean...
Well, okay. I don't understand why we're even talking about sustenance. And
I agree, because I
would have thought that would be the first thing you said. Sustenance is not the word.
Well,
I mean, it's not the word that's ever been in a statute, I don't think, except it's been in a proclamation. And it's used in Maxim to mean exactly for their own consumption. I mean, that's the only way I can read the sentence and the cite, one after another. So why are we talking about the word sustenance?
The word sustenance was used in some older statutes pre-1941. I think there was, but we honestly...
Where?
I would point you to the appellant's brief at page 17, where they talked about sustenance, and they're referring there to statutes that were in use apparently until 1941. And there it's talking about for their own consumption, take for their own family use.
But that's not the word sustenance. That's the appellant's brief. I've got that in front of me. Page 17.
So...
I don't see it.
Okay, well, that
I thought the reason we were talking about it because that was the crux of the argument that was being made.
the crux of our
argument.
Yes, the crux of the appellant's argument, the claimant's argument, it does revolve around sustenance, because sustenance has been a word that's been associated with the scope of the Aboriginal rights recognized in Massachusetts. But from our perspective, we're here defending the judgment on the libel action.
Okay, but maybe, I don't know, maybe I'm not understandable. It's a word that has been around the notion of Aboriginal rights. Yeah, it's here. I see it. It's in the case in Maxim, but it's equated to what the statute says, which is, quote, for their own consumption. In other words, the word sustenance is not in any statute. Maybe it's in the one about animals. I don't know. I guess it is. But we have an entire argument built around a word, but the word is not the operative word. There's an operative word that has to do with what happened to the defendant here, which is commercial. That's in the statute. And then there's this word here, these words here, which are for their own consumption. And it seems to me it's obvious that means eat. And commercial is to be distinguished from not for business purposes. And why aren't we talking about what the words are in the statutes?
Well, I agree that we want to talk about only what's actually relevant to the matter before the court for the court to affirm the judgment. I guess in sort of maybe to help the court Obviously, we're not arguing sustenance, but the Maxim case did use the word sustenance, and I think that a lot comes from there, that when the Maxim court said that
I think it's a mistake to use the word that's not in the statutes and to allow it to be developed into something that it is not. That's a mistake. That's exactly how we see the law go off kilter. I'm talking because you represent the Commonwealth. That's how we see the law go off kilter a lot. And it's really helpful to go back and actually find out what we're really talking about. Now, I have a question about the commercial, the sort of what Judge Ditkoff's been asking about and your first argument, which is you say he was operating as a commercial fisherman.
yes.
And therefore, we don't need to worry about this. He's not
Don't we need to
operating
worry
with
about
respect to his
sustenance or-
Aboriginal
yes.
rights. I understand that argument. My question is this. Looking at Maxim, there is a suggestion that Native Americans are, quote, not subject to shell fishing license requirements. Is that true?
Well, there,
In other words, if Mr. Pocknet had decided he didn't want to get a commercial fisherman's license, he just went out and he shellfished. And maybe he provided those shellfish to a co-op, a Mashpee Wampanoag co-op, and they went out and sold those. Can the government regulate that?
Your Honor, I'm going to respectfully decline to answer because I do think that that's outside the scope of this case, and I'm not here prepared or authorized to represent for the Commonwealth their complete position on Aboriginal rights. I think for this particular matter, what we see is that if you were to not affirm the judgment, we're asking you to affirm the judgment, but if you were to send it back, the only reason it really gets sent back is to have a development of what Aboriginal rights apply, the scope of them, whether the scope is for personal consumption or whether it's broader to include commercial scale. It also goes back because these particular fish were taken from Green Pond. In Green Pond, there's an affidavit in the summary judgment record. It's not clear that Green Pond is actually
Or any Aboriginal rights at all, because it was never
Right.
used at an Aboriginal stage. I
Right.
get that.
So here,
But we're here today to ask you to affirm the judgment because it is.
here's what's confusing me.
Okay.
Officer Opie comes, he talks to the Big Rock Oyster, and he tells them to sell the oysters. And the proceeds are $480. Is that what Big Rock Oyster got from the customers?
No. So Sergeant Opie's report is in the record, and there's a narrative. It's at the
Yeah.
very beginning of Record Appendix
Reading
1.
that.
There's a narrative of what happened. What he says is when he does his administration inspection at the dealer, he sees that they've been bagged and tagged with a harvester tag with Mr. Pocknet's DMF permit number, et cetera, as is undisputed. He says to the dealer, I'm going to libel the fish. Fish being perishable, you libel the money that the dealer was going to give to Mr. Pocknet, which is the $480 check. And he says, and then he allows the dealer to presumably resell the fish because there is no indication that they need to be destroyed.
Why did the Big Rock still have Mr. Pocknet's check?
Well, because they were sold and then they were getting invoiced, and the payment had not yet been made to Mr. Pocknet. There was going to be an issuance of a check, and Sergeant Opie got there that quickly that he informed them after his inspection or at the conclusion of his inspection that he was going to be libeling.
It's super weird that the Commonwealth seized these fish and then didn't take the whole proceeds, their whole value. The Commonwealth seized these fish, they're entitled to seize the fish, that's what he says in his complaint. Then why wouldn't they take the whole value of the fish? I understand why they have to be sold.
Well, the $480 check represents the fish. They seized the fish, yes, that's the libel theory, but because of the perishable nature, all that there really was to seize was the $480 check. They don't take the fish
to think of it
twice.
as the Commonwealth selling the fish then to Big Rock Oyster? Is that what you're suggesting?
I'm suggesting that they libeled the fish, which once, and that was the $480 check that represents the fish that got taken.
The value of the fish before they were sold, but they don't, all right, okay.
And I don't
Going in
have,
circles
I don't
now,
have,
so.
if you, I don't have an answer for you as to why they wouldn't have then tracked any resale and determined, you know, then taken that money too. I mean, I don't know how far down the chain that would go, but they libeled the fish.
Is Big Rock supposed to know what days commercial fishing is allowed? Let me so put another way, did Big Rock do anything wrong?
Yes.
What did they do?
They bought fish
From a
that were...
commercial fisherman that were bagged and tagged appropriately and in compliance with however they're supposed to get them.
And were taken unlawfully because they were taken on a day when from Green Pond on a day it was not open for commercial fishing.
So then why would they get to keep them and sell them again? I mean, I'm sure they made more than $480 on 1,600 oysters.
I don't have an answer for you. I do think that the fish were not contaminated, so they didn't go to waste.
So why didn't the government just take them and throw them back in the water?
At that point, I'm not sure if they would have been safe. If they were, I don't know enough to know if they were alive to be able to go back into the water safely.
Yeah, selling dead oysters, right?
Yeah. Well, they were frozen. I mean, they were bagged and tagged, and they were in the cooler.
Okay.
That's what they were found.
The government was entitled to take it all, right? Including the profit. Big Rock Oyster wasn't entitled to keep its profit. Government could have taken that too, right?
I'd have to submit a 16L letter. I don't know, because we were not going after the profit. We were going after the fish. That's the nature of the libel action. And the libel, but because they're perishable, potentially they could have. No, I'm actually, if let me step a moment. And maybe I need to decouple the idea that this libel action flows from a citation. The libel action doesn't flow from the citation. A libel action could stand independently on its own. For instance, if you're out in the water and you see lobster traps set illegally, maybe they don't have a tag, so you don't know who they belong to. Environmental police can seize them, take that, and libel the lobster traps. There's a case I cited in my brief.
Has to be a proof of a violation of law.
It has to be a violation of law, but the citation itself
Yeah, I get that.
is to a person. The libel is with respect to, in this case, the fish.
That's the other weird thing. Like, why is the libel Commonwealth versus Parknet?
It's not, and I'm glad that came up because the libel complaint is obviously in the record, and yes, it does say Commonwealth v. Parknet, but right underneath that, it actually says as against the oysters. The Commonwealth.
It says one check for the amount of $480 for oysters.
The complaint, the libel complaint is, in Record Appendix Volume 1, page 4. So Commonwealth v. Parknet at his particular address, identifying him as a claimant, not a defendant. And then one check in the amount of $480 for 1,600 pieces of wild oysters. So we were aware that Mr. Parknet was going to be a claimant. As Sergeant Opie's report said, he even called Mr. Parknet after his inspection and said that he was going to be libeling the fish. So Mr. Parknet is identified as a claimant for purposes of him exercising his rights under our general forfeiture statute, chapter 257, to be able to bring a defense. and he had the opportunity to bring the defense in the district court. His defense was aboriginal rights and sustenance, and we say that that defense is not a proper defense because he was acting as a commercial fisher when he took and sold the fish.
Okay, and their defense is, as you said, Aboriginal rights, and yet the Commonwealth is not willing to help me define the scope of what Aboriginal rights are now?
We are comfortable if you were to rule that sustenance means food and drink, that's a ordinary definition of that. I don't think you need to go there, but we're not saying that sustenance would have been, whatever it may mean, would have been a defense to this libel action, because you first then would have to get to the idea that he was not acting as a commercial fisher. We do think he was plainly, that the district court was correct that he was.
But see, the problem with that is he's also acting as a Native American. He can't help it, he is. And so he has Aboriginal rights. So maybe that's right, that because he chose to put on his commercial fisher hat, he lost his Aboriginal rights? Is that the position?
No, it's not our position that he lost anything. It's our position that he was not exercising or any Aboriginal rights, whatever they may be. We're not, this is not.
So it matters what his substantive, subjective state of mind is? I mean, he's both a Native American with Aboriginal rights and he's a commercial fisherman with a license. I mean, I understand the point that Justice Ditkoff made off the top, which is couldn't have sold them to the company he sold them to if he hadn't gone through as a commercial fisherman, right? Because they can only accept commercial fish. But he's got Aboriginal rights. What are they?
Maybe this would help. If Sergeant Opie had ran into Mr. Pocknett on the beach when he had harvested those oysters and had not moved off the beach, that would have been a very different case.
As to which you don't want to answer the question, what rights he has.
Because then there would have been development on that, right? And we don't have that in this case because we know that he took the fish to the dealer and he presented the dealer with the fish and harvester tags, which he admits he puts his DMF permit number on.
I get all that. So what happened to the dealer? Is this like selective law enforcement? I don't understand why, if it's wrong for him to be selling them under a commercial license, and it's wrong for Big Rock, a dealer, to accept or attempt to accept from any person shellfish that was taken from the shellfish growing area or part thereof that is not open to commercial harvest by the division or the municipality that regulates commercial harvest in the waters pursuant to 130 Section 2, and that's what's happening here, then how come there was no action against them, but only against Pocknett?
Relative to Mr. Pocknett and the dealer, the same action was taken. Sergeant Opie exercised his discretion to issue both a warning. Both entities, Mr. Pocknett as well as the dealer, got a warning telling them that they had violated the CMR.
I see.
But Pocknett's profit gets seized and Big Rock Oysters
They get to sell them.
gets to keep its profit.
The fish were seized relative to.
The fish weren't seized.
Yeah.
Well, okay, I understand you're saying, well, the fish were still in the cooler, but the fish were seized once in the sense that the fish being perishable.
No, I get that.
What is Big Rock out? Big Rock was going to pay $480 anyhow. So they paid $480 and they got to keep the oysters and resell them and keep the money.
Okay.
You'd think they would have.
Because this isn't, because.
Is that accurate, what Judge Desmond just said?
I think that what is getting confused here, and it was introduced by the claimant, Mr. Pocknett, is as if this libel grew out of the citation. It did not. So this is not an action. Well, it's important to understand conceptually the difference. This is an action against in rem, against the fish. And those fish were seized, yes, in the form of the proceeds, as is allowed under the statute, Chapter 2.
But not the proceeds from selling the fish.
Pardon?
But not the proceeds from selling the fish. The proceeds were what Big Rock Oyster was planning on paying Pocknick. The proceeds from selling the fish, minus that 480, Big Rock Oyster got to keep, right? Even though that was Commonwealth's fish at that point. You seized them, right? They're your fish?
Again, so the record does not show that further, there was no further liable as to proceeds from the, I think that would be, to my understanding, would be a matter that if instead of a warning to Mr. Pocknet or a warning to the dealer, there had actually been an action taken, say like a criminal action or something on the civil side against them.
I think the three of us universally are just furrowing our brows over this. We do not understand what you're saying. If you libeled the fish, right? One thing you could do, it seems to me, is you could take the fish. You could resell them yourselves. But instead, you took the money that Pocknet got, but you left the fish in the possession of Big Rock, and they got to keep the money that they got. Is that what the facts are?
Yes, there is an element of deterrence in the fact that instead of the fish getting taken out of the cooler and, I guess, destroyed, they were allowed to be consumed.
So who was deterred by that?
I would say that Mr. Pocknet is
Sure,
deterred.
but not Big Rock, right?
And Big Rock is also deterred because not by the libeling of the fish, but they're deterred by the fact that they got a citation, a warning, right? Which can be
Warning, but a warning wasn't the end of the day for Mr. Pocknet. He got a warning too,
They both got a warning.
but he got hit in the pocket,
Correct.
and Big Rock did not.
I don't have evidence on that. If that was material to the libel, I think further proceedings, but I
understand
don't
it's
think.
outside the record. I'm just trying to look at the equities and the fundamental fairness of what just happened here overall.
Yeah, I think one of the things then, if we're again, it's not material irrelevant to affirming the judgment, but one of the things that happens here is that the fish presumably are consumed, right? And so they're not wasted, and that's an important factor too. But I don't have any other information for you unless you want to direct me to issue a 16L letter relative to what did the dealer sell them for, who did he sell them to, who bought them. I don't have that.
All right, so in a couple minutes, what would you like to tell us?
Well, I don't want to impose on your time, and I do see that my time is up. We ask you to affirm the judgment and rest on the brief.
Thank you kindly. The matter stands submitted. That concludes our business for the day. Thanks to all who helped the session run, court officers, timer.